Right, your Lord.
Yes.
My Lord, in item number 26, the department has filed a counter affidavit. We need to file a reply. Further 2 weeks time may be granted.
We informed.
My Lord, government.
No, this is SSA. Education.
Yes, my Lord.
Government is not to be informed. Huh?
No, my Lord. Government is to be informed. I inform my learned son. It's public, my Lord.
Mr. J. Patwari, Learned Counsel for the petition, submits that an affidavit in opposition has been filed by the respondent number,
My Lord, for all the respondent, my Lord.
filed by the respondents, and accordingly prays that he be granted 2 weeks' time to file a rejoinder date. Item number?
Next one, item number 26.
Filed by the respondent number 3. Praise that. Prayer accepted. Registry to list this matter after 2 weeks on a date to be fixed.
My Lord,
Deeply obliged.
with all humility, my Lord, I'm mentioning, my Lord, item number 51. My Lord, we would like to file one additional affidavit here, my Lord. Though it is for further hearing,
I am for a petitioner.
he is for the, I've taken consent from the petitioner, my Lord.
This is a bench 3 matter.
Bench
sir.
3 matter, yes, my Lord.
Vijay Kumar Singh. Yesterday I could not go to read it.
Right.
What was that issue?
The promotion from assistant executive engineer to executive engineer, madam. And I should not be given promotion, madam. Considering that one dependent proceeding is pending against me, two dependent proceeding is pending since 2017, madam. It was not completed, madam.
Yes. What is the additional affidavit you want to bring on it?
My Lord, the instruction is that, my Lord, there was a query, my Lord, as to whether his, they raised that there was a DPC, my Lord. So,
Whether his case was kept in seal cover.
No, madam.
no, my Lord,
That was also not gettable.
the query was, my Lord, whether they have gave a date that there was a specific DPC. We will bring it on record that there was no DPC. We did not do any DPC on that date.
Then how were the others promoted?
My lord-
In June, my others were promoted, madam.
My Lord, we will bring everything on record. That is what my Lord.
Mr. Learned Counsel, Learned Standing Counsel, PWD, submits that an additional affidavit on behalf of the respondents represented by him would be filed on or before
Within
When-
10 days, my Lord, we will file it.
I don't know. On or before 25/3/2026. Registry to list this matter again on 30/3/2026. Yes, Mr. Sri.
30.
I may be allowed to, my lord, move an unanswered motion today, my lord.
What is
Transfer
that?
matter, my lord. Transfer matter, my lord, day before yesterday, transfer was issued, my lord. I
What is the
filed it
transfer
today
from where to where?
From Kokrajhar to Dhubri, my lord.
Why?
He is in the verge of retirement, my lord. And my lord,
Verge of retirement means how many days left?
my lord, 10 months are left, my lord, his service career,
Within 1 year.
within 1 year, my lord. That apart, my lord, there is an interim order operating in his favor, my lord.
By this code.
My lord.
Same transfer order.
Another transfer order, status is operating, my lord. So,
Production.
May I place lordship? Lordship, I beg to mention for listing, lordship.
I also pray for listing.
Listing matters, give it. Yes, what happened?
because of subsequent development, yesterday, lordship select list published, and the most of the seniors, petitioner also, they have not been appointed, lordship. So I have to file a fresh petition, lordship. Here, lordship, today regarding.
Mr. Ek Deka, Learned Counsel for the
Regard-
petitioner, on instruction submits that after the filing of the present petition, the respondent authorities have filed a select list
Yes.
for promotion to the post of headmaster for promotion against the vacant post of headmaster existing in provincialized high school situated within the district of Morrigaon. In view of the said development, he prays that he be permitted to withdraw the present petition and make a challenge to the said select list. Prayer is not objected to by Mr. S.M.T. Sisti, Learned Standing Counsel, Department of School Education. Also, accordingly, the present petition stands dismissed with liberty to the petitioner to refile the same if the occasion so arises. Refile the same, assailing the subsequent developments taking place in.
Obliged.
Compulsory appointment, Lordship.
Those matters have been sent to AGs for views.
What happened if this is the principle? Why the other 17 have been appointed? Revoke them also. You revoke them. 18 persons were recommended together, 17 appointed, and one is left out. That cannot be. If the principle is applied, apply equally. Okay, fine. Ms. K. Fukon, learned government advocate, prays that she be granted further 3 weeks' time to complete her instructions in the matter. She submits that the matter is relating to the appointment of the petitioner in pursuance to the recommendation made in his favor for appointment on compassionate grounds by the state level committee is under active consideration of the respondents. Accordingly, registry to list this matter again on 1/4/2024. No further time shall be granted in the matter. None appears for the petition on call. Registry to list this matter after. After 2 weeks on a date to be fixed by.
Bless.
This matter may be taken next week, my lord. In this case, I have not received the instruction, my lord.
Wait. Wait.
My lord.
Instruction was sought for first on 31/2026. So it's more than, then again you took time on 13/2.
My lord, next Monday, my lord, I will take instruction.
Why? Why? Why is the instruction not being furnished?
District.
It's a limited prayer.
I don't.
Anything very serious.
No, my lord. No, okay.
Hmm?
Three-month salary. Due to non-receive of finance SIU approval. That was the reason.
Something you don't know to say. Don't have the material to say that this is the reason. That much, at
My-
least we can expect from you. Who is not giving you the instructions?
My lord, perhaps it our lapse, my lord. We have not communicated to the department, my lord. Monday, my lord, next.
On the prayer of Ms. S. Chutia, Learning Council for the Learning Standing Council, Elementary
My lord.
Education Department, the matter stands adjourned to 18/3/2026 for completion of our instruction. This being the third occasion when the matter is adjourned to enable the respondent, to enable the Standing Council to receive their instructions in the matter. No further adjournment shall be granted in the matter. And in the event the instructions are not placed before this court, appropriate orders as would be mandated would be considered to be passed by this court.
Obliged.
Yes, what has happened?
The instruction is as similar to the yesterday's matter, my lord. The Hailakandi district, my lord, similar. Fill up কৰিব পাৰিছে।
Okay, now tell me,
My lord.
how is this selection of 2023 being continued till now? That rules says a different procedure.
Says
Why this?
every
Have you
year,
held the review DPC? or you are continuing with that select list of 23?
That instruction will I'll have to
This
specify.
is what we want.
Because the,
Yesterday it was only 8 posts. And then, okay, fine. But
Hmm.
today it seems that you are not following the procedure required. Heard Mr. S.K. Deka, learned counsel for the S.K. Das, learned counsel for the petitioner. Also heard Mr. B. Kaushik, learned standing counsel, secondary education department. Mr. Kaushik, on instructions, has placed before this court an instruction received by him from the director of secondary education affairs. This court has perused the same and finds the same to be cryptic. No reasons have been assigned as to why the vacant posts available in this vacant post of principal available in provincialized schools in the district of Gulaghat. This is Gulaghat has not been considered for recruitment in terms of the provisions of the 2018 rules, Assam Secondary Education 2018 rules. Mr. Kaushik, the Director of Secondary Education Assam shall, on or before 31/3/2026, file a detailed affidavit in the matter, explaining the recruitment process undertaken and as well as to why the vacant posts available against the vacant posts of principal available in provincialized higher secondary schools in the district of Gulaghat has not been taken up for a recruitment.
headmaster.
Headmaster. Provincialized high school over it. Also, register to list this matter again on 2/4/2024.
In this case, notice has not been issued.
Let notice, we'll see why notice is required. There is no private respondent here.
There's no private risk.
Interim order passed earlier to continue till the next date of listing.
Right.
Or you want a notice and a longer date, we can do that. After around 6 weeks. That will satisfy you.
Okay.
Lordship, I request to take the matter for the time being.
Please, your lordship. My lord, petitioner is a retired teacher of lower primary school, my lord. His pension is, my lord.
Okay. That
Started.
recovery already made.
No, my lord.
The money has not been released to you.
Yes, my
Then
lord.
that is recovery only. Heard Mr. M. Islam, learned counsel for the petition. Also heard Mr. B. Kaushik, learned standing counsel.
I'll be for 1 million.
Elementary.
1 and 3.
Elementary Education Department appearing for the respondents number 1 and B. Kaushik. So also heard Miss
B. Bora for
P. Bora, standing counsel BTC, and Miss D. Das Burman, learned government advocate appearing, learned government advocate. Full stop.
6 and 7.
The petitioner in the present petition has assailed the recovery of an amount of rupees 4,51,505 from his pension and pensionary benefits, denoting the said amount to be the excess salary drawn by the petitioner due to wrong fixation of pay, wrong fixation of his pay. Also, issue notice returnable 4 weeks. Mr. B. Kaushik accepts notice on behalf of respondent number 1 and 3. While Mr. A. Cholia.
1 and 3. 1 and 3.
While Mr. A. Cholia, learned standing counsel, Finance Department accepts notice on behalf, just inform him,
Yes.
for respondent
2
number
and 9.
2 and
9.
9. Ms. B. Bora, learned standing counsel, BTC accepts notice on behalf of respondents number 4,
6.
6,
7.
7,
9.
7 and 8.
8.
Uh,
7 and 8.
9, my lord.
9 also.
9.
9.
Actually, you had 2 good, but 8. While Ms. D. Das Burman accepts notice on behalf of the respondent number 5. Post up. No, all the respondents are represented, no formal notice, huh? Post up. The recovery made from the pension and pensionary benefit of the petitioner shall be subject to the outcome of the present writ petition. The respondents on the next date of, by the next date of listing shall bring on record their affidavit and therein indicate as to whether the petitioner was in any manner connected with the fixation of his pay, which had led to the drawal of excess amount.
Highly obliged, Your Lordship.
Registry to list this matter after 4 weeks.
Please, Your Lordship. This petition pertains to the non-consideration of the child care leave law.
We allow it.
Lordship.
We are allowing it.
Lordship.
But your prayer is in the month of February. That is gone. That is gone. That period is gone.
That period is gone. Actual Lordship, for that period, I did not go to school and I joined on 16 to
Oh,
2026.
that is the
Lordship.
portion.
That period to be considered as
Okay.
60 Lordship. That is my prayer.
Mr. B.B. Ahmed, Samat.
Ziad Hussain Lordship.
Huh?
Ziad Hussain.
Zaid Hussain,
Yes.
counsel for
My lord,
the
in this
petition.
regard, my lord, she has not submitted any application before the department, my lord. It is reflected in the order itself,
You get it?
my lord.
Her application in the reflection in the order is that your inspector of schools had said, inspector of schools or DE
DO.
had said that she had not filed a separate application because he had required her to apply for 30 days.
It is.
She directly went to the director.
Right.
And that period she has already undergone. Now she wants that period to be regularized as CCL. That's all.
Lordship.
Also heard Ms. S. Chutia, learned standing counsel, elementary education department, appearing for the respondents.
My lord, 1, 3, 4, and 5, my lord.
So and Mr. A. Cholia, learned standing counsel, finance department. Also issue notice, returnable 4 weeks. Ms. Chutia accepts notice on behalf of respondent number 1, 3, 4, 5, 4 and 5. While Mr. A. Cholia accepts notice on behalf of respondent number 2. No formal notices. Petitioner to take steps for service of notice upon the respondent number 6 by way of registered, by way of speed post. Steps within 2 days. Registry to list this matter again after 4 weeks on a date to be fixed by.
Lordship.
May I please, Your Lordship. So area family pension of the petitioner, Lordship. And for several communications, but no action has been taken. Your Lordship, kindly see page number 20 annexure 4.
Mr. Chaudhary,
Yes,
date of death of the husband,
yes, that was in the year 1997, Lordship.
no date,
1997,
date.
7/5/1997, Lordship.
7/5.
1997.
In synopsis, it is 6/5. Synopsis, it is there.
And gone one day, what difference is it?
Oh, sorry, Lordship.
Then what happened after 97?
Then Lordship, subsequently, if Your Lordship kindly see the order.
No, after 97, were you receiving family pension?
No, that was only in the year 2003.
No, why? Why did you not? Your name was not there in the.
I don't know, Lordship. There is no communication. In
And from
spite of
97 till 2003, you did nothing.
nothing was paid to the petitioner.
Nothing was paid.
Exactly, Lordship.
When the first payment PPO was issued in.
Yes. And
So a
the-
fresh PPO was issued in.
yes, Lordship. Kindly
When?
see this. On the PPO number, it is there in annexure 5, page number 21.
I'm sorry, there is no PPO in page number 20.
Yes, Lordship, the number is reflected, Lordship. The family
It's in
pension.
page
right number-
19.
Page 21 is also there, Lordship. 19 is there and 21 is also there.
21 is a.
So the PPO number
presentation
is-
from your principal.
Exactly. The PPO number has been mentioned, Lordship.
Oh, the PPO is here.
Yes,
17/10/2018.
yes,
The PPO was.
yes.
issued. Now the PPO was issued from when were you paid?
Since 2003.
From in terms of this,
Yes,
with effect from
2003.
17/5/2003. Now, what amount did you receive?
From 17/5/2003, Lordship, we have made a specific statement in annexure 4, page number 20.
That is not a statement, that is an annexure only.
Exactly, I'm saying about the annexure. The statement is there on the part of the petitioner
Hmm,
in the representation.
hmm.
Further, the dues for the period from 1/1/2014.
Where are you, Rehan?
That's
Read
from
the
middle.
details also, huh?
In this connection, it is to state that my husband, late such and such, expired on 6/5/1997. Accordingly, family pension will be effected from
You
7.
can read that top portion.
Yes. With due respect and humble submission is to bring your kind information that in referring to a letter number such and such regarding family pension of my husband, late Rakhal Bandhu Das. 80, the area payment of pension drawn by me with effect from 17/5/2003 instead of 7/5/1997. So this is our case, Lordship.
No, come down.
For the following breaking period as mentioned below, 17/5/2003 to 6/5/2004.
So this period you have not been paid.
I have paid, already drawn. It is there,
This whole thing you have drawn.
drawn.
Now the balance is
Is from 7/5/1997 to 16/5/2003, and from 7/1/2014 to 13/12/2017. These two periods we have not received, Lordship. We have been repeatedly communicating with the authorities.
okay.
Yes,
Now you are after 17, you are getting regularly.
exactly, Lordship.
Now show me with the 17 thing, now you are assailing in 26. If I even apply Tarsem Singh, 3 years.
No, Lordship, the fact is that even the community.
Yes, Lordship, the Tarsem Singh is staring at me.
Exactly, that and, but the communications 21, 23, page number 22.
Representations does not extend the period of limitation.
But the reasonable expectation was there
That
on the part of the
reasonable
petitioner.
expectation has been dealt with in Tarsem Singh. That the balance arrears, if there are, can be recoverable only through a period of 3 years prior to filing of the writ petition. Now, what do you have to say?
But since the petitioner has not been communicated the reason, so the cause of action is
We
always
can't
there.
even ask them now. We can't even ask them.
The cause of action, the continuity of the cause of action.
Continuity of the cause of
Because
action.
if they
Yes.
say no, Lordship,
No,
yeah,
continuity of the cause of action
yes,
is not there because from 1/1/2014, you have been again been paid.
no,
Sorry, 18. 1/1/2018.
yes.
Till date, you have been paid. You had no grievance.
No, we are not on the present amount, Lordship. We are saying about the area amount.
Area.
Because there
show me
is,
the law.
yes, I can understand that this 3 years period is elapsing. But the fact is that there is no communication on the part
And
of the
after
responding authorities.
2018,
Yes, Lordship.
you have not even raised any grievance for around 7 years till you issued this office, this legal notice.
Prior to that also, Lordship, there is a representation. and
Forget it.
duly
Page
communicated,
20
Lordship.
onwards is our representation.
Yes, Lordship.
So that is in the year 2018.
18.
Everything is 2018. Now in 2025, you file a central legal notice and come up before this court. Whereas
No, since 2018, the communication was there. There is no response on the part of the authority.
communication stopped.
Yes.
Thereafter, you were happy. Why should we allow the
No,
husband
the
to-
fact is that this representation was submitted 78 years old lady Lordship. He had submitted the representation. He was waiting some response from the side of the respondents. If the respondent is
7 years you have waited.
Lordship,
7 years you have waited.
we are expecting something from the respondent authorities.
Keep that expectation on. We will close this matter and say that continue to expect. I can't go beyond Tarsem Singh.
But the fact is that Lordship, these documents is showing that there was no response.
Document showing this was known to you. If you were not paid the amount today, say you were not paid. Forget the payment made. You were not paid. In spite of the issuance of the PPO, you were not paid. You come up after 7 years before this court. Arrears would be payable to you by this court. From when? 2015?
Exactly.
Not more than that. Same principle will apply.
In between that, if there is some communications. then-
Sorry, show me the law that the
No.
representation extends the time of limit.
I'm not saying about the representation, Lordship. I'm saying about some communication from the side of the respondent authorities with regard to the, then I will file my additional, give me 1 day time so that I can file my application.
Why 1 day? Take 1 month. No problem for me.
Any day in the next week, Lordship, I will obtain the necessary instruction.
On the prayer of Mr. SP Chaudhary submits that he would explain He would file an additional affidavit
Exactly.
explaining the delay occasioning in approaching this court, claiming areas of pension that are due to the petition prior to 31/12/2017. Also, the petitioner, with effect from 7/5, petitioner claims that the areas receivable by her of family pension areas receivable by her with effect from 7/5/97 to 16/5/2003 and 1/1/2014 to 31/12/2017 have not been released to her. However, the petitioner is drawing her due pension with effect from 7/5/2004 due pension with effect from 1/1/2018. The petitioner has approached this court claiming areas which are claiming family pension which are in areas for a period prior to 31/12/2017. So it is in the above background that the petitioner has sought for an adjournment today to bring on record an additional affidavit. So prayer accepted, registry to list this matter again after 2 weeks on a date to be fixed.
Obliged, Lordship.
That is. Let the petitioners are the stipendary teachers were appointed.
That Purnima Hore will have to
Yes,
be applied.
yes.
We'll give them a short notice.
Son.
Heard Mr. Ed Hoc, learned counsel for the petitioner, also heard Mr. A. Fukan. AA. This is double A kiss. Learned standing counsel, elementary education department. Also heard Miss Ardas. Datta, learned counsel appearing for Mr. S.K. Medi, standing counsel, accountant general bracket A&E Assam. Issue notice returnable 3 weeks. Mr. Fukan accepts notice on behalf of respondent number 1, 1, 4,
And 7.
1, 4, and 7. 1, 4, 7, 8.
8 1.
1, 4, 6, 7, 8.
6, 7.
While Mr. A. Cholia, learned standing counsel, finance department accepts notice on behalf of respondent.
2 5.
Mr. Cholia, we have been using your name in other cases
Lordship,
also.
yes, sure.
2 and 5. While Ms. Datta accepts notice on behalf of respondent number 3. All covered? All covered. The respondents in the elementary education department shall apprise this court as to why the case of the petitioner would not be covered by the decision of this court. Where is that decision? Cited?
Citation is
6403 of 21.
A decision of this court in the case of Purnima Hore and another versus State of Assam and others reported in 2023 SSC online GAU 1166.
obliged, matter.
Similar matter, my lord.
Now, what is the direction that was there in the earlier order that has not been complied with?
That is in the provisional select list, my lord, they have not mentioned about that, my lord,
What?
about the direction, my lord. No, it was,
Provisional select list, I think we have not made that.
no,
that
yes,
statement.
definitely.
Then why
They,
did you put in
no.
that statement?
it's appointment letters. Basically,
And moreover, Lordship, pair 1, Lordship, issue, Lordship, I see the pair 1, the notification death challenge. That was already been that challenge in that Rupamra case, that was in dismissed, Lordship. Not annex of 14. The notification regarding verification that they have to submit the certain amount, 6 numbers of documents for verification. You can NIS this.
it is under challenge before the
No, it is
decision.
understand, but this challenge has already been dismissed, Lordship, that in the single.
Whether that bursts me to challenge that.
You take a preview.
Yes.
The NZ Khatunia Jaga, page 108, SMP 60, Learned Standing Council, Department of School Education. Respondents are same,
Same, my lord.
I am for 1, 2, and 3 only, Your Lordship.
1, 2, and 4, 5 steps together. Same advertisement?
Same advertisement.
Okay, same.
Lord, maybe tagged with
Uh-huh.
the earlier one.
Register to list this matter, last of the
WBC 842,
along with
842.
842, no?
last of along with WPC number 179,026.
My lord, WBC 842 of 2020.
Sorry, 842 oblique.
Party नाम है
Page 802 में other than
अच्छा sir. Interim नाम है तो page 109 पे
842 so. The 4 weeks long.
much obliged, my lord.
My lord, appeal was also filed. It has also been dismissed. Only thing is, my lord, I'll pray for a returnable date, my lord, after 4 weeks.
Because of the inconsistencies you have highlighted.
Yes, yes. And my lord, there are a lot of infirmities. Anyway, today I'm not pressing all these ones.
But Mr. K.N. Chaudhary, Learned Senior Counsel, assisted by Mr. A.U. Ahmed, Learned Counsel for the petitioner. Also heard Mr. K. Gugwe, Learned Standing Counsel, Higher Education Department. Issue notice, returnable, not a full stop. The petitioner in the present petition has essayed an order of penalty imposed upon him, order of dismissal from service, removal from service imposed upon him by the disciplinary authority, by his disciplinary authority after conclusion of a departmental proceedings instituted against him. The petitioner has also essayed the appellate order passed in the matter by the appellate authority's order dated 27/2/2026, rejecting the appeal preferred by the petitioner against the order passed by the disciplinary authority. Also, the petitioner in the present writ petition has projected that the order of removal from service as imposed upon him has been so imposed basing on an enquiry report which stood vitiated on account of non-extension to the petitioner reasonable opportunity to defend his charges. It is also projected that the petitioner was not permitted to cross-examine the departmental witnesses during the enquiry. Also, issue notice returnable 4 weeks. Mr. K. Gugwe, Learned Standing Counsel, Higher Education Department accepts notice on behalf of 4 also.
No, 4 I cannot.
Or 1, 2, and 3. No formal notice. Petitioner to take steps for service of notice upon respond number 4.
I think, my lord, 4 can be deleted.
That is better. Mr. K.N. Chaudhary, Learned Senior Counsel, at the outset had submitted that the respondent number 4 may be deleted from the array of respondents. Also, prayer is not objected to by the Learned Counsel for the respondents. Accordingly, respondent number 4 stands deleted. Petitioner to file amended cause title in the matter within 2 working days. Accepts notice on behalf of number 1, 2, and 3. Also, Mr. K.N. Chaudhary, Learned Counsel for the petitioner has prayed for an interim direction. Also, issue notice on the interim prayer, also returnable after 4 weeks. Also, the Learned Counsel for the state respondents, Mr. K. Gugwe, before the next date of listing, shall either file his affidavit in the matter and or produce the records in original for perusal by this court on the returnable day. Raised it to list this matter again on 6/4.
After 6/4.
2024. Tuesday. 20 is Monday. Motion admission matter.
20.
20, 201. 2004-2020. If you either file an affidavit dealing with that point, or you get the record. That's
I'll place.
yes, Ms. Suti.
No, this,
They are
my,
Purnima Hore covered people.
Yes.
my,
You gave it to them in 2015.
my,
They'll get it from the date of their stipend, that they'll be under the OPS only. GPF account has not been opened.
Not that.
Ms. S. Chutia, Learned Counsel for, I heard Mr. Ayat Choikia, Learned Counsel for the petition. Ms. S. Chutia, Standing Counsel, Elementary Education Department submits that she be granted 2 weeks' time to complete her instructions in the matter. Registry to list this matter again on 30/3/2026, on which date Mr. Chutia shall apprise this court of the stand of the respondents in the matter.
Can be first, my lord.
30?
Can be first of every month.
Okay, 1st of April. Yes.
I straight away apologies. Straight away apologies. I don't know how I missed 2 dates, my lord. We came into into the litigation on 8th of 11th.
You deprived us of the sadistic pleasure of dismissing.
I bow down to your lordship. This is my complete mistake. I take complete responsibility for it.
Yes,
This court is not that strict. We have not dismissed the matter for 2 days.
No, but still it is not
Yes.
done on 2
It
occasions.
happens, it happens. Forget it. What is left here?
So I understand, my lord. I was supposed to come physically, not well. I couldn't make it today. I have a
Mr. Fukan, we are very much accustomed to the online method. There is no problem. Please go
all
ahead.
I'm saying, my lord, is that I am under the impression that anything may not sustain in this litigation at all. I am to just take an instruction. If you can give me 2 or 3 days time, my lord, I'll come back to your lordships. Only in regards to the fact that the challenge was initially to that appointment of so and so, who till date continues to be in that post. Now he retires. I think what I have been given instruction on the last occasion is that he retires next year. My client still has around 4 years of time to retire. The petitioner Sanchita Boro along with the others. So I'll just take that instruction, my lord. If your lordships can just give me some time, I'll accordingly come
But
back to you.
Mr. R.B. Fukan, Learned
I'm
Counsel,
once again, I apologize for the
No,
for the
Mr.
long appearance.
for at some length. Also heard K. Gogoi, Learned Counsel, Higher Education Department. Mr. Fukan submits that he be granted 2 days' time to receive further instructions in the matter. Prayer accepted. Registry to list this matter again on 18/3/2026 for further hearing.
Extremely grateful, my lord. My apologies once again.
I think nothing survives. Let Mr. Fukan have.
Yes, I'll just come back to your lordships on 18th. Extremely grateful.
May I please your lordship?
Yes.
Petitioner, he has given more than 14 years of service. So thereafter, he did apply for the regularization. And we had also previously filed a writ petition. Thereafter, the Honorable Court was pleased to ask the department to dispose all the representations of the petitioner within 30 days.
This is a what school? Elementary, secondary.
Secondary.
Then
So now the thing is that one sanction post is still vacant there.
you are still working.
No, I'm not working. I have been removed from the job.
Show me your right. Show me the right you have accrued.
I
As
was
an
going to-
honorary teacher, as an honorary worker.
No, your lordship, if you see in the main petition, that is Annexure F, the department have told that I
Which
was
is
working
the
as
authority in
ad
the
hoc.
department who told you that they are going to appoint you? Which is the authority shown?
No, not for the appointment. As per my representation in the main petition, that is Annexure E, department have replied to the director saying that I was working as an ad hoc.
Not an ad hoc. You are working as an ad hoc, honorary, engaged by the school management committee. Not by the government.
No, I was, it's a grade 4.
Who appointed you?
Yes, I was appointed from 210, your lordship.
Who appointed you? Who is the authority appointing you?
Selection committee was there in the school, they have appointed.
Selection committee of the school. There is no reference to the government. Why should the government regularize you against a post? You are not an employee of the government. You are not working under orders of the government. You are not a government employee. You have not been appointed by a governmental authority.
No, as far as Uma Devi's case, your lordship,
Uma Devi's case. Fine. Very good. Tell me, what is Uma Devi?
paragraph 53, one aspect of it needs to.
That is in a government service appointed by a governmental authority. Here you are appointed, your very entry is bad, illegal. Yes, what do you have to say?
The thing is that your lordship, yes. Now they're saying that I've been appointed in Barbell, but that is not in my knowledge how come.
Mr. Dev, just show me that you have been appointed by an order passed by the authorities.
This is the problem. I don't have the appointment letter, your lordship. But I've been given the identity card.
And show me, where is your sentence that you were appointed by the inspector of schools?
Not inspector of the school, by the
School managing committee.
Managing.
Admittedly after provincialization. And in this court, we follow a hierarchy system. The higher division, higher forums order, we are bound by it. A division bench is already, a decision is already holding the field. I think we give it a quietus. We'll have to dismiss it.
No, I've been given the identity card from 210, saying that I've been working in the grade 4.
Oh, which is the authority who gave you that assurance? Just spell out that
At
authority.
that time, headmaster have issued the identity.
Headmaster, school managing committee, file a civil suit against them, claim damages.
Okay. And I've been. This is other particular, but I've given 14 years of service. There was nothing.
14 years of service not under the government, not engaged by the government, by a school managing committee. You.
Actually, selection board was formed that for that board has selected me. But unfortunately, I don't have all these documents. I've tried it.
My sympathies are with you, but legally I'm bound.
Lordship, after Damodar Kalita's case, your lordship, the division bench has already made it very clear.
Can you give me a copy of that?
Lordship, I'll give it. Lordship. And now your lordship appointments in grade 4, they are made by through direct recruitment, your lordship, to the
You
commission.
participate.
Lordship, he can participate.
Subject to your eligibility.
Eligibility, your lordship.
But he is
Maybe
over
given
age,
age
46
relaxation.
years. 46 years.
56.
He's working there. For that period, condone, consider.
Lordship.
That much I can do for
Yeah,
you.
that much. My age may be controlled. Age control.
Who?
It will be done by the commission.
Whoever it is,
Lordship.
he'll apply.
Lordship.
He'll apply. 14 years, honorably.
years,
We are not giving him any benefit of that. But let him participate.
Lordship.
He is working there
Lordship.
till your passing of this order.
Lordship.
25, 31, 25, and you have come now. Oh, this was there earlier. Okay, we'll pass the order in the second half. You give me the
Lordship, I'll give.
second half, 2 o'clock. We'll.
Lordship.
Okay, the age may be controlled.
Huh?
Age of the petition of this.
I'll not condone. You will appear. You will apply for condonation. They will consider that much. Only I can't condone. I don't have that power to condone.
That's it.
Or you show me a judgment that I have the power to condone. Why condone? I'll allow you. I'll appoint you. Show me that power. That executive power we'll always love to have. Why not? 226 power, along with that, the executive power also comes to us. Nothing like it. But
Okay,
we
the
don't
main
have
case, notice is issued, your lordship. Can you wait for the notice for the reply of the department? In the main case.
that. I'm disposing of the main case only. I'm not hearing you in the IA. Want some time to prepare further?
Yes, your lordship.
Mr. B heard Mr. B Deb at length. Ms. D. Musahari had raised a issue with regard to the maintainability of the present petition. So, Mr. Dev submits that he would make further submissions on this said issue on the next date of listing. Accordingly, registry to list this matter again on 26/3/2026 for further hearing.
Lordship.
26/3/2026 for further hearing. If you can get something, bring it. I'm there. Otherwise, you know the order.
Right.
Hey, give me that.
Lordship,
I cannot find it.
Lordship.
Just, my Lord Justice Gogoi is no.
Ye-
There's an order of.
Lordship,
Justice
when
Gogoi.
Lordship, I'll place it.
Right.
Oblige your Lordship.
But Mr. D.S. Deca, learned counsel for the petitioner at length. Hearing, and Mr. D. Bora, learned government advocate at length. Hearing concluded, registry to list this matter again on. What is it? 6/4/2024 for delivery of orders.
Much obliged, Lordship.
We are ready, but I have another 3 to pass today, so I'll not be able to.
Much.
Yes.
Yes, my lord, only point, my lord, asked clarification from learned other side regarding whether or not, my lord, his name appeared in the eligibility list in the website.
That always.
Yes.
Yes, Mr.
10 minutes, our instruction is on the way also. After 10 minutes. Also.
May I please your lordship? My lord, today itself, I am going to file the affidavit, my lord. I have already served the copy to my.
Mr. B.K. Das, learned counsel for the petitioner. Also heard Mr. B.D. Das, learned counsel appearing for the college. No. You're for Mr. Goswami, you're for?
For 8 and 9, my lord.
Respond numbers 8.
I have been given a copy and I see the same grounds have been repeated. I don't know.
Mr. B.K. Das has submitted that an affidavit in reply on behalf of the petitioner has been filed today. So, registry to list this matter again after on Ketia. When?
At the earliest, my lord, can be closed.
On 19/3/2025, along with 26, along with the set.
My lord, on 18th or any other day, not 19th.
20?
Or 20th. Much obliged.
Done.
Lordship,
Regularized.
the government has directed the Director of Elementary Education Department to proceed in accordance with that OM, Lordship, of 12th September 1996. That OM is also the second phase. Last page is the OM, Lordship.
What is your case?
My lord, petitioner
In the basing on the office memorandum dated 12/9/1996. Show me, you were appointed as a temporary employee.
my lord, page number
Ad hoc and temporary are two different things. Temporary appointment is against a substantive vacant post. And he holds that post in substantive capacity, but probation, temporary, be that as it may. In his case, a confirmation is required. Right? If that confirmation is given, then if he does not have 20 years of service also, he is entitled to pension. But a muster roll employee appointed, he works. He will not be confirmed because he is working against a personal post. So in his case, this office memorandum would apply and 20 years of service would be, qualifying service would be required. How can that office memorandum be applied in your case? Rightly so, the government has questioned the earlier regularizations of 2 or 3 persons. There are 21 of the earlier thing. Now tell me how it is to be.
I know by applying this OM, similar to,
That is a error committed. That is an error.
similar
I got it.
person
I got it.
already getting their pension, my lord.
Do you want one more ground in your favor? You were given leave encashment. You were given GIS, right?
My lord.
You were given CPF, GPF, but still no pension. All said and done. That money you got, you keep it. But all said and done. You were not in the regular stream. You're not a government employee.
My lord, but similar situated person already get.
That similar situated persons, they are trying to now taken up the matter with the director, how it was done, government.
They have not mentioned.
No, affidavit was filed in a rush because this court wanted. Now they have realized. Now they have realized, and rightly so. Okay. Mr. P.N. Sharma, Learned Standing Counsel, Department of School Education has placed on record a letter, a communication issued by the, who is issuing this? By the
Deputy
government in the
Government.
Department of School Education to the Director of Elementary Education to clarify as to why permission was not sought from the government for regularizing, for grant of ex post facto regularization of the services of persons similarly situated like the petitioner. The said communication also requires the director to examine the matter after due consideration of the office memorandum dated 12/9/1996, a copy of which has also been placed on record. Also, on the next date of listing, Mr. P.N. Sharma shall place before this court the response of the Director, Elementary Education to the said communication dated 13/5/2026.
13/3, Lordship.
13/3/2026. Registry to list this matter again after two weeks on a date to be fixed by.
Date will be given. It's
Date, okay. On 27/3/2026.
27th.
deeply, please.
Actress, take equity, actress, 31/3. Well, he'll be very busy, very busy, very busy.
Of the record, lordships, these 2 persons, there's no note, nothing in the file, lordship.
That I know.
Nothing.
My lord, 30, I have problem.
Okay. On 6/4/26. 6/4.
Problem.
Deeply.
Madam, you are in trouble.
In this case, my lord, I have received affidavit right now.
Today we had filed it.
See how good they are. Very promptly filing affidavit.
Yes.
And you say they don't file affidavit. They only keep on taking time. This is bad. All are angry with me. Yes, what is your stand in the affidavit?
Actually, my lord, in this case, my lord, there is a appeal provision. May I pray before your lordship that may I go to file appeal, my lord?
You file your rejoinder.
Reply. Yes, yes.
You have only a DSC recommendation. You don't have a recommendation after that.
Lordship.
Yes, yes.
Now, there is a recommendation after DSC.
No, Your Lordship, because,
SLC rejected.
yes, because she was,
My name is
DLC,
not shown actually.
because DLC had recommended her name only for the second post. And, as per our.
And she says that in other schools,
Yes.
you have also accommodated second
Second
candidate.
Hindi teacher.
Lordship, the enrollment has to be there. Enrollment is less,
That
Your
she
Lordship.
has not brought on record.
That is less. We have, it's there in
Madam,
our discussion.
clarify that.
Yes, my lord. Yes, I would like
I'm
to
not
reply.
disclosing it.
Yes.
It'll not be of any use to you. Ms. K. Devi, Learned Counsel appearing for the for the petitioner submits that she be granted
Then I will.
time till when?
After Bihu, my lord.
4 weeks time to file a rejoinder to the affidavit filed by the respondents. Ms. D. Mushahari, Learner, Standing Counsel,
Yeah.
Secondary Education Department does not, secondary, no?
Lordship second.
Secondary Education Department does not object to this set prayer. Accordingly, the registry to list this matter again on 22/4/2026. In the meanwhile, the petitioner to bring on record the rejoinder to the affidavit filed by the respondent.
Obligation.
Pleasure, Lordship.
My pleasure, Lordship.
Hmm.
Lordship, this is the case against the decision taken in the review meeting.
This is a case, I know that. Otherwise, why will you be here? Yes.
Well, we are challenging the review order, my lord. This is the impugned, my lord. What
Who will
happened?
the review order?
Well, that is the last order, my lord. That is at Annex 10, page 33, my lord. My name is CL number.
What is the stand of the government with regard to your
Government is,
statement?
stand is that.
Mr. Burwa,
Oh, yes.
you know the matter, I don't know. Let me also understand. Come to your level. What is the stand of the government with regard to your plea that you were appointed as a compassionate appointee in Jorhat Science College? At that point of time, that was under the government.
Yes.
You have made a statement somewhere.
Yes.
What is the reply?
On
No
that
reply.
regard, my lord, they have no any reply.
Yes, Mr. Das.
They have said that, my lord, from the, I have been regularized.
16, when just again became government. Yes, Mr. Das.
My lord, kindly have pay the initial appointment, my lord.
Huh.
Page 15. That was the appointment letter issued by the principal, my
So,
lord.
Principal Science College, Jorhat, at that point of time,
Yes, my lord.
was not under government.
My lord, but prior to that, my lord, earlier annexa may be.
Oh, you want to argue, make a cricket commentary, continue. I'll keep my ears shut.
But kindly see the content, my lord. This is temporary appointment. Subject to dismissal without notice and without
Mr.
assign-
Das.
Yes, ma'am.
Please make your submissions carefully.
Ah.
This is not an appointment in air. This is an appointment approved by the government in the previous page. See,
My lord, then see the second paragraph, my lord, the previous letter. What it says, my lord, you are therefore requested to initiate appointment after checking the roster point reservation and seeking necessary clearance from so and so, if required, and after due police verification by the concerned appointment authority. He was directed to initiate the appointment after
what is this
verification, my lord.
appointment?
And my lord, in my
What is this appointment?
the
This is not an illegal appointment. It's not an irregular appointment. It's an appointment on compassionate grounds.
compassionate ground, my lord.
Ah.
But
So, this, I only want to know whether Science College at that point of time was under government. Mr. Esdas, you get that instruction, we'll consider after some time. Get your telephone instruction. If he was a government employee, then sent to an autonomous body, then again come back, how can you treat that period to be not?
But here is the thing, my lord. If here the
Okay,
petitioner
okay,
I'll-
temporary appointment.
temporary appointment.
Okay, come
Then
to
he-
your
then the
affidavit. Where have
petitioner
you?
did not
Okay,
challenge, my
Mr.
lord.
Das,
That order.
where have your director or whoever it is taken this plea in the affidavit?
My lord, just a moment. Paragraph 10 and 12.
Okay,
Paragraph 10
you
and
find out, you tell me when you get it. We'll take up the matter immediately.
2.
Not to, when Mr. Das gets the instruction. Mr. Das,
Yes,
that
sir.
plea is not there. So please don't take pleas which you have not taken in your affidavit.
What I remember, my lord, we have taken that he was not a.
You have taken the only plea taken is that it came back to government, just was brought under government.
Yes, my lord.
from a date in 2016.
16, my lord, 16.
Only from that date he will get. But he is having a service, government service. How can you ignore that?
And those two letters, he never challenged, he accepted, my lord, the
Which
petitioner
one?
accepted.
Which
The
one?
first temporary appointment, the initial appointment letter, and the letter
Show me
whereby
that
he has been regularized.
denied, he has been denied MSCP taking that period from the Annexure 2
Yes, ma'am.
onwards, because that appointment only gave him a temporary appointment, not a substantive one. Just show me from the records, I'll dismiss Mr. Hu. Just show me that. From your plea in the affidavit also.
From documents, my lord, they
Documents, affidavit, it's not to be taken. Reason.
take again.
Documents is from your respondents, not you.
Yes, ma'am.
You are only putting it in a cosmetic, with a cosmetic exercise, you are putting it before us. But that face has to be there in your affidavit, right? Otherwise, where will you apply cosmetics? Show me that face.
Yes, ma'am.
And then I'll dismiss. I assure you.
After some time, ma'am.
After, whenever you're convenient. When you're confident that you have it, tell her.
Yes,
Ditya Mata Motitiva.
obliged, my lord.
22. 21. Wait, 21.
21.
My lord, in this case, my lord,
Nothing has been done till now.
nothing has been. And there is no.
What are you getting?
My lord, other things I have got.
Only the
because
pension.
As provisional pension I am getting, but the final pension hasn't been made. And
DCRG?
Then DCRC.
DCRG also, provisional DCRG also not given.
Provision has been paid.
No.
But
Provisional pension, provisional DCRG.
provisional DCRC is
Not.
And regarding, my lord, that auditor has clarified the, my lord, this my lord, position, my lord, at Annexure 6, page 18.
Ms. Musari,
Lordship,
you
lordship,
have seen the file,
lordship,
seen the
lordship,
facts.
lordship.
Now tell me, let us presume that the husband of the petitioner had misappropriated that. It's not misappropriation. It is a temporary adjustment from the MDM fund to the construction fund with a letter to the government. Kindly release this money so that we can recoup that MDM account. Let us see he has misappropriated.
Lordship.
Is it permissible for you to drop a proceeding against him? If your authorities can't appreciate that simple matter, can't help it. We'll have to now impose cost. If this simple matter is not being permissible to be appreciated, when did your husband die?
My lord, 26/3/2021.
26/3/21, 5 years, this lady. You have given her a provisional pension, but that is only a pittance.
Lordship.
Provisional DCRG, regular pension. Get some amount in this old age. That would be the only,
Lordship, I can understand. Yeah.
the resource she has, that so that somebody takes care of her. Children may be good, they will take care. But her own independent thing, why are you depriving her of that in the evening of her life? We are taking up this matter again
Lordship.
on 30th.
Lordship.
On that day, I want the pension proposal prepared and sent to the concerned. I'll give you time, more time. I'll give you time till 1st.
Lordship.
In the meanwhile, the pension proposal has to be prepared and forwarded to the Director of Pensions.
Lordship.
Heard Mr. M. Sharma, learned counsel for the petitioner. Also heard Ms. D. Sharma. You are appearing for?
5 and 6, my lord. Respondent number 5 and 6.
Administrators and the managing committee.
Managing committee.
You have not given the non-liability certificate.
No.
No, no money.
Why?
Uh,
Why?
Actually, wrote the letter to the director
Hmm.
and page number 63 and Annexure 3.
The learned counsel for the respondents on the next date of listing shall apprise this court as to the exact reason why the pension proposal of the petitioner has not been processed. The learned counsel for the respond number 5 and 6 shall apprise this court as to why the non-liability certificate was not issued from the end of this call from the school authorities. The instructions shall be placed before this court received in writing from the Director of Secondary Education Assam as well as the headmistress Kachar High School, Silchar. Registered to list this matter again on 18/3/2026 for further hearing.
Thank you.
We will on that day pass final orders. We'll pass the orders on that day. I just want to know.
Yes.
May please your lordship. Lordship is a covered matter, lordship.
Yes, what do you say? Covered?
Yes, madam, they were regularized in the year 2005, madam. So they are coming
Heard Mr.
new persons.
Sri Bodle, learned counsel for the petitioner.
But
Also heard Ms. N. Fukat, learned standing counsel, elementary education department. The learned counsel for the parties have submitted that the present writ petition is covered by the decision of a coordinate bench of this court
Annex D, lordship.
in WPC, coordinate bench of this court in the case of Sukumar Sarkar. Common judgment of this court dated. Order of this court dated 12/8/2021, passed in WPC number 8694/2018. 8694/2018. Bracket Sukumar Sarkar and 7 others versus State of Assam and others, and other analogous matters.
Verification is needed, madam. So
Huh?
verification is needed, madam. So one line may be incorporated.
Hey, there is no verification here.
No verification, lordship. Same category, 170, sir.
The petitioners in the present writ petition. How many petitioners are there? 5.
5, lordship.
5 petitioners have joined together to institute the present writ petition. Praying for a direction upon the respondent authorities to place the petitioners, to extend to the petitioners the provisions of the Assam Services Pension Rules 1962, and to the said extent interfere with the
170 cents.
undertaking received from the petitioners in pursuance to their they being appointed against a regular sanction vacant post by order dated 17/8/2005.
Lordship.
The petitioners in the present writ petition have projected that, it is up next one, that they were initially appointed on honorary basis,
Lordship, no, lordship.
on stipendary basis, right?
They were appointed against vacant post, lordship.
Oh, stipendary,
On temporary basis, thereafter regularized, lordship.
were appointed.
On
So what was your initial appointment?
Lordship, page 20.
Stipendary teachers, madam.
Page 20, lordship. Page 20, Annex A, lordship. The sanction post, lordship. Page 20.
Stipendary है?
Stipend, no.
Were appointed against vacant posts, vacant sanction posts.
My lord, they are not a stipendary teachers.
No, we can say stipend, not we can sanction post.
If they not stipendary teachers, then Punima Hure is not covered by the petitioners, my lord.
Then you said this judgment at page 40 is covered?
No, my lord, we have.
There's a handle for verification. Only
Yes,
if they're
my lord.
covered, if they're covered by.
We are not going to do that. Lekha. But Mr. P. Bodle, learned counsel for the petitioner. Mr. P. Bodle, after placing the facts of the matter on record, has submitted that the case of the petitioners is covered by the decision of a coordinate bench of this court in the case of so and so. What did you say?
8694, Lordship.
Ms. N. Fukas and Mr. P. Cholia submits that they be granted 10 days time to verify as to whether the case of the petitioners, they'll verify.
Yes.
N. Fukan Kodi. Then it's standing council, elementary education department submits that she be granted 10 days time to verify as to whether the petitioners would be covered by the said decision rendered by the coordinate bench of this court in the case of Sukumar Sarkar, bracket. Accordingly, registered to list this matter again on 25,
My lord.
3/2026.
Oblige, Your Lord.
My lord, senior is in leg in another court, my lord.
On the prayer of the learned
Kindly pass
counsel for
over
the
for time.
petitioner, registered to list this matter again after a week on a date to which. Yes.
Lordship, 24 service complete. 25, my lord, there was an order for dusty service and we have served. But affidavit today I have filed. Respond number 7 and 8.
This you have filed affidavit in 25,
25.
4 you have filed affidavit.
No, 24 is already service complete. So far 25 is concerned, my lord. 2677 WPC.
No, you had taken prayer. 4129. You had taken time on the prayer of.
This is 24, Lordship.
Seen the office note dated 3/3/2025. Seen the office note dated 10/3/2026. Service of notice upon respondent number 7 is complete. Huh? The petitioner submits that in WPC number 2677/2024, service has been effected upon the respondents number 7 and 8 by way of trustee mode, and the affidavit in the matter would be filed within a period of 1 week from 2 weeks from today.
Today I have filed, my lord.
Oh, and an affidavit to the effect has been filed today. Then also, accordingly, registry to list this matters again on when?
Any date, Lordship.
After 2 weeks.
Date may be fixed, Lordship.
Okay, listed again on Punnapari 6/4/2024, 26 for admissions.
Much obliged.
Petitioner in the meanwhile to bring on record the affidavit envisaging service of notice upon respond number 7 and 8 in WPC number 2677/2024.
Much obliged.
That's respondent are.
List this matter before any other bench without me. I had appeared, I think, for the government.
But in appeal, Lordship has appeared, I think. Before
Ah,
we admit.
for the government, I appeared.
Oh, yes.
Read appeal.
That's it. Like,
The name, yesterday when I did not go through, yesterday when I saw it was, even when I saw, I knew.
leading counsel Mani and Sharma,
Huh?
leading counsel and Sharma could not come to the court.
He is missing. Sharma is missing.
Not missing, Malak. He
Then?
could not come. But
He is not found.
next week, Malak. Can you take it?
Why? Why not today?
It was directed to go through the.
On the prayer, a prayer is made on behalf of Mr. N. Sharma, learned counsel for the petitioner for an adjournment in the matter on account of personal inconvenience. Prayer accepted, raised it to discuss matter again after 2 weeks on a date to 3 weeks on a date to.
Mass oblige.
Appointment letter has already issued.
Issued. None appears for the petitioner on call. Ms. S. Borua, learned CGC, submits that the appointment letter appointing the petitioner Ms. None appears taken. Ms. S. Borua, learned counsel, submits that the petitioner by communication dated 22/3/2026 was informed about his provisional selection for appointment as constable bracket general duty bracket over in CISF. Puso. The said offer of appointment dated 2/3/2026 is also submitted to have been issued to the petitioner. Puso. This court has perused the communication dated 2/3/2026 issued to the petitioner and finds that the petitioner on his provisional selection has been offered an appointment and the authorities have required him to appear to report at the RTC Mundali, MUNDALI, CISF Recruit Training Center, Mundali, Odisha, na? Orissa. Also, in view of the above development and the petitioner having been issued with an offer of appointment, this court is of the considered view that the grievance of the petitioner raised in the present writ petition has been redressed. Also, there being no further live issue arising in the present writ petition for consideration, the present writ petition stands closed. A copy of the order communication dated 2/3/2006 and the forwarding thereof as furnished by Ms. S. Purva is kept on record and marked as X for the purpose of identification. Mr. Cholia, what are you waiting for? T4. Huh? Okay, Seniority.
May I please, Your Lordships?
Yes, Mr.
Your
Burger.
Lordships, last orders, Lordships. The copy paste order earlier already set aside by this Royal Court, Your Lordship set aside.
Yes.
Exactly stated.
Where is Miss Pukongan? He was supposed to, yes.
Affidavit send it for waiting, Mela, so sometime maybe allotment.
I don't want your affidavit.
Mine.
You see the last order. We have to
Yes.
draw contempt proceedings against you. Hey, Didier, you read this order and tell me what to do. After 2, 3, I will take it up after some.
At 2 p.m. lordship.
Bili kiman ase? Bili kiyor asile? 6906. Oh, Sneha, let us in it. Yes.
22.
Yes, Mr. Dole.
Earlier, the petitioners have been working as my teachers in schools in BTC, my lord. Schools in provincialized also. And they've been working,
When?
my lord. In under 2017 rules, my lord, they have.
Yes, Mr. Bora.
Lordship, I'm running short of a copy of the writ petition, my lord. So I may be served one, my lord. And also, my lord, regarding provincialization, my lord, state will be the authority, my lord.
Yes, Mr. Pegu.
Sir, my lord, I'm waiting for instruction.
Huh?
I have not received instruction.
To give him the extra copies.
Yes.
Mr. Sharma,
Yes.
we'll have it when?
Any day, my lord. Your lordship.
Before you get into the thick of other things.
The other things I may not get. I may not contest.
Oh.
So.
So there is no loss cost to us.
No.
You will be here with
Yes.
us. Okay. That is a loss for some other. So give me a date. When can you file your affidavit? And mind you, don't just say to get it over today. I'll record. And if you don't file, cost.
That proposal should be come from the BTC, my lord. Thereafter,
Whoever.
BTC completed this part
proposal.
twice.
The Learned Counsel, I heard Mr. R.P. Sharma, Learned Senior Counsel, assisted by Mr. Dole, Learned Counsel for the petitioner. D. Dole, Ms. B. Bora and Mr. G. Pegu, Learned Counsel, appearing for their respective respondents, have prayed that they would file the affidavit in the matter on or before the next date of listing. Also, the affidavit not filed, even the affidavit is not brought on record before the next date of listing, this court would consider grant of further time to file such affidavit only on payment of costs, which would be determined, if so mandated, on the next date of listing.
Lordship, already.
Registry to list this matter again on 22/4/2026. I've given you enough time.
Yes.
Lordship, already petitioners have submitted that from BTC, my lord, it has already been.
You don't know. You bring it on record.
Yes.
They dispute.
Lordship.
You know that. You know that fact.
Lordship,
No, forget Mr. Sharma. You know that fact.
no, my lord,
Then-
I do not have.
No,
the
you
copy.
get-
Yes.
Get the idea and then file. Mr. Pego, be very careful.
That was it.
My lord, regarding Sahala order, we could not found the order, my lord. That is why we could not,
Which form the order?
last order, my lord.
This order.
This is not uploaded. My lord, that is why I could not pursue the order, my lord, to the department, my lord.
এটা photocopy করে দিয়েছি।
This is,
Also, I know that.
no, সেইটো আপোনালোকে হে পায়, আমি নাপাওঁ।
What happened in our e-service portal, Lordship, we do not see the last.
এটা copy তুমি এইটো কৰি কেনে দি দিয়া। The court, Ms. N. Fukan submits that a copy of the earlier order dated 9/3/2026 has not been able, Ms. N. Fukan submits that she was unable to access the order dated 9/3/2026 passed by this court. The courtmaster to furnish a true copy of the order dated 9/3/2026 during the course of the day to Ms. N. Fukan, Learned Standing Counsel, Department of Elementary Education, Assam. Ms. Fukan shall complete her instructions in terms of the said order and apprise this court about the stand taken. Registry to list this matter again on 27/3/2026.
My lord, 2070, I'll not be available.
26, 25, when? 24,
I will out of this station, my lord,
when?
on 2nd
From-
April, 2nd April or
No,
3rd
no, no.
April.
From when are you out of station?
23rd April.
23rd. On
23rd March, my lord.
on 23, 2026.
My lord.
Please
Online
speak.
copy is available.
Huh?
I learned if I appear last talk as a.
Boy, her is very advanced mobile. The small things don't catch there.
Sorry, Lordship.
This is Apple plus plus.
It's Lordship. I'm like.
Yes, Ms. Surya.
Well, after 2 weeks, my instruction is awaited, my lord.
Yes. Why is your salary stopped?
My lord, without any reason and without any.
Is there
communication-
any other person between you and above you in the school? Forget the upgradation as first teacher. By the date of joining, is there anybody senior to you?
No, my lord.
No. Ms. S. Chutia, learned counsel for the petitioner, prays that she be granted time till 27/3/2026 to complete her instructions. Prayer accepted. Registry to list this matter again on 27/3/2026, on which date the learned standing council, elementary education department shall invariably apprise this court as to why the salaries of the petitioner has been stopped after he was provincialized in his services.
Obliged.
Yes, Mr. Chowdhury.
Discussion.
It's great to see you after a long time.
I'm
Yes.
coming occasionally, but not here.
I was inquired that you were not here. You were in Bombay or somewhere outside. They told me you were outside.
Only last week I was away. Otherwise,
But I've not been finding you. I've
No.
not seen you.
unfortunately, there's
Oh.
no case before you.
No, sometimes
Yes.
month or back, someone I just inquired from someone. Not seen sir for a long time. Where is he? That sir is outside. Daughter's place or something. That was given to me. What is the matter?
Here it is for regularization and salary growth.
Hmm.
Government took time for filing of the affidavit.
We have not received any instructions, so some time may be allowed, man. We have wrote a letter to the district, my lord, so some time may be allowed.
There was some defect in my petition also. On the last occasion, I corrected it, my lord, in February. And submitted press copies to the department.
Okay. When will you have your instruction?
After 2 weeks, man.
You give me a date. You think over it 2 weeks, 3 weeks,
For-
4 weeks,
first-
1 year, whatever it is.
First week of April.
First week of. Miss N. Fukan, learned counsel for the respond. I heard Mr. D.P. Cholia, learned senior counsel, assisted by Miss M. Roy, learned counsel for the petitioners. Also heard Miss N. Fukan, learned standing counsel, elementary education department. Ms. Fukan submits that she be granted time till 1/4/2026 for completion of her instruction. She submits that in the event the affidavit is not filed, she shall furnish before this court instructions received in writing from the competent authority with regard to the stand of the respondents in the matter. Registry to list this matter again on 1/4/2026.
Payment of arrears.
Oh, 2000.
Actually, I've given a. The jurisdiction now is purview of the Director of Secondary Education.
But the school is amalgamated
Amalgamated.
in the year 2022. It is earlier petitioner was as an assistant teacher of Nis Ghawarappa Girls Selfie School.
You are now an employee of the secondary education,
Yes.
amalgamated school. You're
Yes.
getting your salaries.
Yes, Lord.
From which is the period involved here?
Here a period is involved 2008 to 2013. He was suspended. Petitioner was suspended. Thereafter, he was
2008 to
2013. 5/1/2008, he was suspended. Later on, he was reinstated on 29/2013. And as per communication submitted by the District Elementary Education Officer Kasar Silchor, 2019 Lordship, Annexure 8, page 23, Lordship, for requirement of a fund, Lordship. Addressed to the Director
So
of
you
Education.
were reinstated on 29/2013.
Yes, Lordship.
Any departmental proceeding?
No proceeding is initiated.
So where is the order reinstating you?
Yes, Lordship. Page 14, Lordship. Last paragraph, Lordship.
And the school was amalgamated on
2022, Lordship. Page 15, Lordship.
25/4/22.
25/4/2022.
It's given in the email or instruction.
And submission for proposal for requirement of fund for payment of the arrear salary in the year 2023/7/2019, Lordship.
That period was serving.
He was serving, but then
The period.
that is true. But since yet, community processing.
22 amalgamated.
Exactly. Side of. Yeah, this.
Yes.
Lordship,
What is this reasoning you have given?
Lordship, the, we are given that,
2019, it could not be done.
because there was no budget.
1920, it could not be done, right? 2021, it could not be done. Now that 22, this school has amalgamated, hands up.
Jurisdiction.
But why did you not do it for earlier? Now, who is the authority who has not done it? Director. Inspector of schools, director and
Elementary education.
elementary. We are imposing 12% interest.
And
that amount should be paid, recovered from the departmental officials who had caused, even your secretary, who had caused this thing. I'm giving you 1 hour time. At 2 o'clock, I'll take it up, get your instructions.
My lord, can it be on Monday, my lord?
No, today.
My lord, Monday, sometime I can get, my lord, because I'm appearing for the first time.
Sometime you have been, your authorities had time from 2009. Your
This is
order,
the instruction I got.
your order, and what is this instruction you are, who is this authority giving? The director.
In charge.
Is this the manner instruction is given to a court? What is there, Mr. Fukan? Nothing. Just evasive. And a poor citizen is suffering. And this is the order. Page 14. You have not questioned this order. His reinstatement by a deputy inspector of schools. You have not questioned it.
No.
He is reinstated. He is getting his thing. Now, how can you deny? Where is your suspension order?
Page 13, Lord.
And how could he have been placed under suspension by a deputy inspector of schools without that being ratified by the higher authorities? The whole suspension is beyond the provision, beyond his jurisdiction.
No proceeding is initiated. Discipline.
Yes, then what happened? Why are you giving a commentary? I'm interacting with somebody. 2 o'clock. Ask your director what she means to say with that. And get that written instruction, what she meant by this letter. Then we'll see what we do.
Bless.
Maybe. Only dash code. Dash code was allowed me shoot to a school 2009. And that is going on. But in suddenly we learned in 2024 I was ill, my headmaster was ill.
That period is over, September.
Yes. Two period.
No, sir, that dice code can be corrected in September.
But at the time I have filed application, I was ill. I have medical is given me, my lord. Sorry. So that
Yes,
is
what is your instruction, Mr.?
that is
This has to be by SSA. Have you made SSA a party?
my lord.
Respond number 5. Who is respond number 5? Mr. B. Chaudhary.
Till at the time of filing, submitting their dash code perform, my lord, I was ill, so I given me a medical certificate, etc. my
Get
lord.
hold of Mr. Bora, Mr. Chaudhary, Mr. Gogoi, Mr. Nayak, or anybody. We'll see what can be done. Get hold of them.
Or so,
Or you want an adjournment?
then at 2 p.m. my lord, I'll in the meeting.
We have some orders to deliver. I don't know whether we can take it up at dot 2 p.m.
No, then I'm not at 2 my lord. Then it's my Monday, my lord, my Monday.
On the prayer of Mr. A. Roshik, London Council for the petitioner, register to discuss matter again after a week on a date to be fixed.
Monday, my lord, 16 of showing the name of the my lord, SCC advocate.
Name is not shown.
One minute, was list
35.
36.
No, shown.
Then my lordship.
Navarun Midi. 37. Yeah.
My lord, in this matter, B. Kosik will appear, my lord. He is on leg in another court, my lord. So after some time.
Petitioner is the only qualified teacher to hold the post of headmaster in the school. The other teachers, those who are having the B.Ed degree, they have not completed 10 years of service, my lord. I was not appointed because I was transferred from another school within the same district. Now, as the my lord, seniority is determined on the basis of district or seniority, I should have been appointing instead of appointing the
Where is your transfer order?
my lord. Page 23, my lord.
Okay. You have received your instructions.
No,
Then?
I have. In this matter, my lord, B. Kosik will appear here, my lord. No. What's one and I want to just check it, man, whether instruction has come or not.
Now that is under a rule that has been done, rule or act that transfers are done.
My lord, the transfer under the rules, my lord, it is said that, my lord, if it is transferred on own request outside the district, then he will lose the seniority.
Where is that provision?
My lord.
Under which rule? 2018.
2018, my lord. Page, rule 29, my lord, page 46.
What is it?
It says, my lord, rule 29 2, my lord. Transfer if on own request of any employee from the school of one district to school of another district shall forfeit the seniority of their earlier school. I was transferred within the same district.
72.
40, page 46.
46, my lord. Rule 29 2.
This is a high school.
High school. Earlier it was as school or seniority, my lord.
Now it is district wise senior.
My lord.
Okay, we'll let Mr. Kaushik come, we'll hear him and then pass over.
Smiles.
And Mr. Sharma, if you don't have it.
Yeah.
Receive your instructions, whether an incumbent transferred within that district only can lose his seniority. He cannot, because
But my lord,
under the 2018 regime, the cadre is district. And that whole schools, provincialized school in a district form a single cadre. Because you are promoting people to headmasters
yes.
in different, it's not the same school. 2003, it was school-based seniority. So that's the difference. Just have your instructions, why keep it pending, we'll dispose it of. Otherwise, you have that 10 years,
Yes, but there's
15 years and beard, everything. Here.
everything.
Oblige, my lord.
May I please, Your Lordship? Lordship, item may be passed for time.
Pleadings complete.
Actually, Lordship, I am not gone through it.
On the prayer of the Learned Council for the petition, raised it to this matter again after a week on a date 2 fixed.
That is. The contempt petition, my lord. Order was passed in the year
58.
58. Sorry.
None appears for the petition on call. For the ends of justice, raised it to this matter again after a week.
59, Lordship.
58.
59.
We have already filed our affidavit.
Lordship, this matter may kindly pass off for time. 59.
What is your stand in the affidavit? No affidavit has come on record. Mr. Fukan, where is the affidavit?
Lordship,
When did you file?
I've not filed the affidavit, my lord. Last time your lordship had asked the other previous
no.
counsel to bring.
Mr. Sharma said that affidavit is filed.
No, that is a different case. That the previous case.
Oh, 56. That affidavit, 57 affidavit. Yes. 58 affidavit filed, yes. 59, what is the stand, Mr. Fukan?
The lordship had asked on the previous occasion, the last standing counsel to bring the record, my lord. Here's the record of the SLC.
He was not found eligible.
My lord. Your lordship got it, my lord.
Mr. A. Fukan shall file an affidavit bringing on record the minutes of the SLC meeting, SLSC's meeting, wherein the case of the petitioners were considered. Such affidavit be filed within a period of 2 weeks from today. Registry to list this matter again after 10 days. Yes.
That matter.
Yes.
Similar matter is pending, your lordship. Similar this type of matter.
On this case, we found that the contents have also been disposed of, rejecting your claim. What more is there? Why trouble the government again? And tell me about your stand in the writ petition that it is required that that interpretation of the clause language teacher means a language teacher for each language.
The section 3111, what it has said that there should be minimum 3 teachers. Less than 3, not possible. But the word language has been used in a plural sense, languages, because the legislature.
Languages here means that any languages,
suppose
whoever is senior.
Suppose your lordship in the ME school, one Hindi is compulsory. Assam is also a compulsory subject, and English is also a compulsory subject.
You will have English, Hindi, Arabic,
No.
Assamese, Boro, 8, 9 teachers only of languages.
No, so far
that cannot be the intent of the legislature.
No, why Hindi language? Why I'm saying, your lordship, when initially the venture school came into being.
You are not Hindi here. You are
here Arabic, your lordship.
Arabic.
Arabic. Now, Arabic was a compulsory subject.
For that, you make a challenge to 311 before the division bench.
Even what I submit is by plain reading also, your lordship, there is no it is not a case that there is any restriction that language teacher cannot be given, and there is also no specific requirement that only one language teacher has to be given.
This is in a negative sense. In case of venture primary, upper primary, there shall be minimum 3 teachers or tutors. So 3, out of that 3, 1 will be science, 1 will be social studies, 1 will be language. That much only.
It is minimum requirement. The 3 must be there. But the legislature knows that Hindi is a compulsory subject, Arabic is compulsory for madrasa.
We don't know what the legislature knows. We
Even
don't.
there is a letter.
We'll only go by the plain reading.
Even there is a letter by the director, your lordship.
That letter is prior to 2017.
Yes, prior to 2017, because there is a problem after 2017. There is a problem. Director has
No, this letter is, I think, prior to 2017. So what we do? Dismiss it. 19/12/2019.
19, yes, your lordship. Even the director feels that because there are languages and director feels that
you pursue with that.
Who should be given priority?
So with this, you file a writ petition assailing the provisions of 311, saying that this is not being interpreted in this manner. You'll have to get a declaration to that. We can't do anything.
Lordship can also interpret it.
I can't, and I will not, because my interpretation is that.
No, then how this dilemma will be, lordship? Hindi
dilemma will be there until and unless the provisions of 311 exists as it exists today. Nothing further can be done. You will have to make a challenge to that provision, a division bench. Get that provision out. Make it open.
Generally, interpretation of statute is like this. Lordship knows that it should be harmoniously construed, that it should not create any doubt. It should not create any confusion.
I'll construe that word language in the context it is used.
Language.
It is used in the context of 3 teachers. So I cannot add words there. And I should not be adding words there to the legislature. Legislature said 3 posts, minimum.
With a prefix of minimum.
Minimum
3
posts. Out of that minimum, again, it is out of that minimum 3 posts that they have broken it down. It's not the posts which are there in this school. It is minimum 3 posts. Further breakdown, 1, 2, 3. 3 is languages. So everything will be within that 3.
Yes. Now 3 languages. Who should be given priority?
That's not there in the rules. And if whoever is the senior most will, amongst the language teachers, will get the priority. That would be the simple interpretation required. And that would be a logical interpretation also.
And from the directors that are...
Because what happens is, if the court lays down that no, the discretion would be with the authorities. Now the question would be, say a Hindi teacher is there, an Assamese teacher is there, an Arabic teacher is there. The Hindi teacher is found to be very close to the authorities' powers at be. He'll be picked up. In another school, same combination, an Arabic teacher may be picked up. In another school, an Assamese teacher. Where is that uniformity? So the uniformity would be maintained provided that these would be on the basis of the senior. Simple.
Now, since there is a letter by the director, the government must also clarify, your lordship. They can clarify how they have.
They have clarified in the, I've seen that in the contempt. You have that letter with you now?
No,
Fine.
last day they could not furnish.
They'll furnish you that. They'll furnish you that, don't worry. Wait for that. And in the meantime, I think we'll give it a closure. And we'll deal with it that this is. And you have not even specified, you have not even set out the number of students in this
No,
school. If
regarding
you want, you
student-
withdraw, file with better particulars individually. This is an individual, but
case.
the particulars are not there.
The students, so far as students, I don't have the students. Therefore, I did not ponder on that, your lordship.
Then what is the big thing in provincializing you? What is the public interest involved? In provincializing you, when there is no student to study Arabic, why should the court direct them to provincialize our service? Just to sit there.
Because they have.
There may be a school wherein there is no Assamese students taking Assamese.
No.
Or Hindi. It may happen. There may be no student in Barak Valley in a class where Bengali is not taken. Maybe.
They have not taken any clue from the department that whether Hindi students are there. Altogether, students have been taken out. That is a total number of students. But subject-wise, they have.
There need not be. It's not required in a.
For example, in Barak Valley, your lordship, Assamese is a compulsory subject. Now, there has to be a teacher of Assamese in the Barak Valley school because Bengali is otherwise their own language.
But that is not the prescription in Lower Assam.
That is not the prescription in Lower Assam.
What can we do?
Now, so therefore, your lordship, this person.
This school is admittedly in Lower Assam. The school is admittedly in Lower Assam. So we
they
don't
have
have that.
put in their maximum years of service with a hope that their services.
Sympathies are with you, but sympathies cannot override. But mine should be always add.
My submission only is that your lordship, the act has not said that there cannot be any other teacher. Or
We'll consider that and reject your appeal.
let it come next week, your lordship. Similar matters are also. Lordship has adjourned.
That day I'll let
adjourned
you.
one matter.
Okay. Following parity.
I am deeply obliged, lordship.
On the prayer of the learned counsel for the petitioner, raised it to list this matter again in the next week. The plea of maintainability raised by Ms. N. Fukan is kept open to be decided on the next date of listing.
I'm so obliged, lordship.
Yes, Mr. Gogoi.
Lordship. তুমি কোন শুনে যাচ্ছ কাগজ কোন আছে বাইদেউ
Forget papers, you tell me what it is.
That particular document which was supplied in Annexure 7 is lordship. It is not in existence in the office record also. Page 27, lordship.
Annexure?
Lordship.
That is annexure?
Annexure 7, page 27, lordship.
Give me 2 minutes. Okay.
Lordship.
Show me from your affidavit that you have taken this plea.
That was not there,
Then-
lordship. That was not there.
then-
lordship. That was
then-
not there. That was not there, lordship.
then
Permit, we can.
Today you, why should we permit you? That has to be
Otherwise,
taken.
also on the basis of that document, I can argue lordship case. On the basis of the,
And,
presuming that,
this document,
presuming that.
okay, Mr.
Lord-
Gulay, just for my understanding.
Lordship.
Now, is there any other list published after the Annexure 7 list before issuance of Annexure
It
8?
is not there. That instruction I have not taken, otherwise also probably not
You
there.
can have that
Lordship.
Inspection will take it up at.
Yes, today itself, even Lordship, presuming that that particular document is a genuine one, then also I can argue the case, Lordship.
Yes, please, sir.
I can argue that. Then he can finish it, then
He's finished. You argue.
So Lordship, for a moment, we presume.
Just a moment, no? Only also, my lord, page 31, whether 31 exists or not, that may also be given reply.
That
by my
exists.
lord. 31, my lord, annexure 9, because there is something there.
That exists.
That's it.
Okay, what is your stand here, Mr.?
Lordship,
What is your stand here?
in this
On
case,
the basis of 27.
case,
27.
No, that provincialization.
regarding his provincialization,
Hmm.
Lordship. His provincial as per 2017 Act, Lordship.
Why was he not provincialized under the 2011 Act?
At the relevant point of time, he was not
We
considered.
are not even bothered. 2017,
Lordship,
if this
Lordship.
goes 2017 holds the way.
Lordship.
Now, why the 2011, when he was found to be qualified for provincialization, others were provincialized, he was not provincial.
That part, on the basis of that particular list, Lordship. On the basis of that particular list, as per the office record, it is not there. Officers stated in the affidavit.
So which is the list which
Lordship.
led to issuance of page 20?
Issuance of page 29, Lordship.
Which
Page-
is the list?
Then Lordship, record have to call for, Lordship.
No, that's what we wanted from
Then
you.
record have to call for.
That is what we wanted from you.
Record have to call for.
Simple as that.
Otherwise, Lordship, if we go by this particular document, Lordship, then also Lordship is not entitled, Lordship.
Oh,
Not entitled. Then my lord may kindly. It's not a Lordship 10-4 Lordship notification, Lordship.
that is what I want you.
It is not a 10-4.
So where is that 10-4 notification?
That document cannot be treated as a 10-4 document, Lordship. I am relying.
You
on the
show me the
45.
10-4 document. Forget the decisions, we know that. You show me the 10-4 document.
Then Lordship, record have to call for, Lordship.
That is what exactly I did. That is what I wanted you.
Record was not called for.
No, I wanted you as to whether the statement as annexed in Annexure 7 in format 1 with a title qualified list is a list so published after completion of the verification process under section 4 of the section 10 of the Act of 2011.
That's why they said that that particular document is not
Okay,
existent.
fine.
If
You
that
have a
document is not
10-4
existent,
you
Lordship,
have a 10-4 list, that means.
then Lordship, record have to call for. Lordship.
Mr.
Record have to
Gogoi,
call for, Lordship.
Learned Counsel for the Learned Standing Council, Higher Education Department submits that the list as annexed to Annexure 7 of the petition is not available with the respondent authorities. Also, in view of the said stand taken, the services of the employees of the set of the college of BH Science streams having been provincialized by order dated 21/2014, Mr. Gogoi shall on the next date of listing place on record the notification issued under section 10 bracketed 4 of the Assam Venture Educational Institutions bracket provincialization of services bracket over Act 2011, which had basing on which the said order dated 21/2014 was so issued, invoking the provisions of section 4 bracketed 1 of the said Act of 2011.
Lordship.
Raised it to list this matter again next week, but on next week of date.
What are hearing?
6/4/2026 for further hearing.
Lordship.
Obligation.
It doesn't matter.
6-4. So you only hit you.
Yes, Mr. Gogoi, what is your stand here?
My brother will appeal.
Yes, what is your stand?
My lord, at that point of time, that institute was in society mode, my lord.
Science College.
Yes, my lord.
Huh? Science College was Principal Jorat Science. That was in society mode.
What?
My lord, in the annexure
At-
2, my lord,
at the point of-
Gauhati of Assam, annexure 2. Top of the annexure 2, Gauhati of Assam, Office of the Principal, Science College, Jorhat. Next, sir.
Mr. Das, what is it?
My lord, at the time of appointment, my lord,
It was a
2010,
autonomous institution.
Under society mode.
under society mode, my lord, it did.
Jorat Science College? I don't think so.
Just under society mode.
It went to society mode, Jorat Institute of Science and Technology.
JST.
JST. This is not this. This is Science College.
This no any.
This was upgraded as GIST and then put to. Who gave you that instruction that this is in science mode? This is in autonomous body?
Autonomous, they didn't say that autonomous.
Then what did they say?
That before GIST, my lord, it was in
GIST we
society.
don't want. We don't want GIST. But what is prior to GIST? He joined in Science College.
Yes, my lord.
It's a government college. So he is a government servant for all intent and purpose.
My lord,
You cannot deprive him.
my lord, may I submit some name? Then, my lord, the initial appointment, it says that he has been appointed as a temporary employee, my lord. The content of the letter says that, my lord. The petitioner never challenged that he have accepted. Thereafter, my lord, kindly see then. Then page 16, which says that the following government notification of so and so, the government of Assam is pleased to transfer without prejudice to the existing service conditions all the existing posts with incumbents of the Jorat Science College to Jorat Institute of Science and Technology. That means when the government took decision, the existing service condition of the petitioner was a temporary, my lord. So on that service condition, he has been taken into this manner. Then, if my lord take up the affidavit in reply of the petitioner, page 46. It says that with reference to the subject cited above, I am directed to say that in pursuance of government notification number so and so, restructuring the Jorat Institute of Science and Technology, the service of the following 6 numbers of incumbents are hereby regularized with effect from 10/12/2016.
All these incumbents had come from Jorat Science College?
No.
Only you.
Then this is an order of 2018 that has not been challenged, put to challenge till now, and he has accepted. Now my humble submission would be, my lord, unless that order is challenged, that unchallenged order cannot be indirectly questioned, my lord, at a later stage now, when the MSCT benefit is in question.
Where is your ground for that in your affidavit?
Affidavit, my lord, the relevant para will be 12, where we have stated that the OM granting MSCT benefit was for the government employee.
Sir, you are arguing against your stand in the affidavit.
Hello, para 12.
Page 43, second line. So 5th line.
43. 43 affidavit in reply by the petition. Vacant post, Said College of the year so and so, and accordingly by order dated so and so, the principal of the Science College Jorat appointed the petitioner on compassionate ground as grade 4 employee.
So a compassionate ground appointee can never be appointed on temporary.
Yes, madam. That is true, madam. That now, if he has been appointed against that OM or against the provision, then whether that
he has been
that is the
appointed
defective
in terms of the directions passed by the government.
Yes, madam.
By the principal, and you have also said at that point of time it was a purely government college.
Madam, that
So his appointment of 10/3/2010 has to be taken to be a substantive amendment.
Look, the letter whereby the Deputy Secretary of Higher Education.
That is a
says
mistake
that-
you have done. That is a mistake you have done. You
That
could not
letter
have.
says
We are doing it. We'll do it.
to initiate, my lord, initiate appointment. Subject to, my lord, checking the roster point verification. These are, they are
If
formalities, my
required,
lord.
it was not required.
Then
Show me it was required. Show me. You are the government. Show me.
that
Show me.
direction was given, my lord, to the.
Show me. You are now relying on page 14
Yes, ma'am.
to say that page 15 order is bad. Your respondents never contemplated that. Your respondents only contemplated. Yes, you were a government servant, but you went to the mode. When you came back, we again regularized you. Nothing more, nothing less.
Authority, my lord, in my humble submission, didn't say that he is a government employee, my lord. Otherwise, he has not been regularized in 2016, my lord.
43, that line.
43 is the affidavit in reply by the petitioner, my lord. That is his submission.
Oh, his submission. Okay. Where is your submission?
My submission is, my lord.
Okay, that college was a government college. At least that we can get from there.
Yes, my lord.
Yes. Where is your affidavit on that point?
My affidavit starts from page 34. In para 12 will be relevant, my lord. Previous paragraphs, we have stated that about the OM, my lord. The OM says that the
So that is
benefit has
what
to
I'm
be
saying. What about a government employee who was transferred there, who was again brought back to government?
initial appointment, my lord. The letter says that he is not. He is
Mr.
temporary
S. Das, Learned
employee.
Counsel, I'm taking down your cutting. You justify it from your records. Shall I? You justify from the records that that was the reason why it was done.
Then, my lord,
Will not permit you to file an affidavit. You have already filed an affidavit.
I'll not file affidavit, my lord.
But you will have to now substantiate your submission from records.
I'll get the records, my lord, then.
No. Substantiate this point if you want me to. I'll pinpoint it. And if it is not there, we'll be very heavy.
Because
I'll keep it potted.
2016, my lord, that's why he has
That
been
is why, because that is
regularized.
why you took him along with the others. Others are different.
Yes,
He is different. Others are recruited in GIST.
yes, my lord.
He is not recruited in GIST. He went to GIST, transferred to GIST. Transfer means that is by you, that status maintained. Moment it comes back, that thing revives. We'll have to revive. Mr. S. Das, Learned Counsel for the petitioner, submits that he be granted a week's time to make further submissions in the matter. He also undertakes that he will produce the records by which the petitioner was initially appointed and also the records by which the petitioner was, services of the petitioner was transferred to the administrative control of the Gauhati Institute of Science and Technology on the next date of listing. Registry to list this matter again on. How long will it take for you?
But, wait 3 weeks, my lord, I'll get.
We'll have it immediately after vacations on 22/4/2026.
Interim order is there, man.
Interim order passed earlier to continue until further orders.
Well, if possible,
Until the next date of listing.
well, if it is possible, prior to the Bihu vacation, my lord. Because already 23rd, 2023 matter, my lord.
We have 2014-15 matters pending. We'll do that first. Yours is a monetary thing. If we do it 2 days late also,
Yes.
we can restore your benefit. Okay? Nothing that. Mr. Das, be very careful. You go through it meticulously.
Yes, ma'am.
If you find that what you are submitting there is material, place it. Otherwise, give it.
I'll check.
And
the record.
second thing, don't take this plea of temporary appointment. You cannot appoint a person on temporary basis on compassionate grounds. My decision is there. Decision of coordinate benches are there. Supreme Court decision is there. Will not accept that.
I'll go to my office memorandum also is there, my lord. Clause 13.
What does it say?
That the compassionate appointment is a regular appointment against the existing vacancy.
When were you appointed on compassionate basis?
2009.
9. When did that office memorandum come?
15, my lord.
Why are you making unnecessary submissions? Yeah.
Much older.
Mr. Goswami, what are you waiting for? Mr. S.S. Goswami, what are you waiting for?
Item number 4344.
We'll try at, I don't know, but we have orders to pass. I'm not sure whether we'll be in a position to take up. But anyway, we'll see in the second half. We will not wait, we'll see in the second half. But Mr. But Mr. J.I. Borgia, learned counsel for the petitioner. Also heard Mr. P. Naik, learned. Mr. Naik had appeared last time.
Yes.
P. Naik, learned additional advocate general, appearing for the respondent number 1, 2, 4, and 6. Also heard Miss A. Chakraborty, learned counsel, appearing. Also heard Mr. A. Chakraborty, learned counsel, appearing for the respondent number 3 and 5. The petitioner in the present petitioner, by way of instituting the present petition, has raised a grievance with regard to the prolonged suspension ensuing in his case after being placed under suspension while issuance of an order dated 10/2/2025 by the in pursuance to an order dated 10/2/2025 issued by the District Commissioner Dhubri. The petitioner was initially recruited as recruited as a junior accounts assistant in the and was posted to the district and was placed in the district treasury establishment Dhubri by an order dated 7/1/2009. So, on his such placement, after selection, the petitioner was posted to Dhubri Treasury Office. Thereafter, the petitioner was transferred to Bilasipara Sub-Treasury by an order dated 21/2/2009. Next. The petitioner, while continuing as a junior account assistant, a petitioner thereafter was considered for promotion to the post of senior accounts assistant, and he was so promoted in the year 2017. And on his such promotion, he was continued at Bilasipara Sub-Treasury. So, while continuing as a senior accounts assistant at Bilasipara Sub-Treasury, an FIR, basing on an FIR lodged by, while the petitioner was continuing at so and so, a FIR came to be lodged by one Gita Musahari, proprietor of Messrs. H.K. Musahari, on 2/3/2023, inter alia alleging therein about misappropriation of her final contract bill by the executive engineer, PWD Bilasipara, and the staff of his establishment It was further alleged that the amount involved was transferred by the Treasury Officer, Bilasipara Sub-Treasury, to an account which was so opened in the name of the informant, which was so opened in the name of the firm of the informant by utilizing forged documents. Also, the said FIR came to be registered as Bilasipara PS case number 108/2023 under section page 8, underline A2 here. Also, subpara, as the petitioner was being sought out by the police, he approached this court by way of filing an anticipatory bail application, being AB number 2505/2023, seeking pre-arrest bail. This court, by order dated 24/7/2023, was pleased to grant interim bail to the petitioner. Also, during the pendency of the said bail application, the investigating agency completed the investigation and submitted its charge sheet and laid its charge sheet, being charge sheet number 132/2024, before the trial court, before the competent court, and therein also implicated the petitioner. The charge sheet was so laid under section 120B, 406, 409, 419, 420, 34 IPC. Also, this court, on being apprised about the filing of the charge sheet, proceeded wide order dated 5/9/2024 to dispose of the said bail application, requiring the petitioner to approach the trial court for regular bail. The petitioner approached the trial court for regular bail. The trial court, on considering the prayer made by the petitioner, was pleased wide order dated 12/9, proceeded wide order dated 12/9/2024 to enlarge the petitioner on bail. The said criminal proceedings are presently pending disposal. Also, considering the fact that the petitioner was implicated by the police, by the investigating agency, and arraigned as an accused in the charge sheet, in the above noted charge sheet filed in the matter, the District Commissioner, Dhubri, proceeded wide order dated 10/2/2025 to place the petitioner under suspension by invoking the provisions of Rule 6(1)(c) of the Assam Services (Discipline and Appeal) Rules 1964. Also, the said order of suspension having not been reviewed and a departmental proceeding not been instituted within the period of 90 days, the currency of which order of suspension is permissible to be so continued in terms of the decision of the Honorable Supreme Court in the case of Ajay Kumar Chaudhary versus Union of India and others, reported in 2015 7 SCC 291, the petitioner has instituted the present writ petition. Mr. J.I. Barbia, learned counsel for the petitioner, after reiterating the facts noticed herein above, has submitted that although a departmental proceeding was instituted against the petitioner, wide issuance of a show cause notice dated 12 12/8/2025, the petitioner having been placed under suspension on 10/2/2025, the show cause admittedly not having been issued within the mandated period of 3 months, bracket 90 days, with effect from the date of issuance of the show cause order of suspension of the petitioner, the order of suspension had lost its force and the petitioner would be mandated would be mandated to be reinstated in his service. Mr. J.I. Barbia, by further referring to the decision of the learned Supreme Court in the case of the Honorable Supreme Court in the case of Ajay Kumar Chaudhary, Supra has submitted that the respondent authorities, while issuing the show cause notice in the matter instituting a departmental proceeding against the petitioner, had not issued an order extending the period of suspension of the petitioner after carrying out a review therein. He submits that the said order was also not passed after issuance of the has not been passed till date. Also, in the above premises, Mr. Barbia submits that the order of suspension dated 10/2/2025, having lost its force, the same would mandate an interference from this court with a further direction to the respondent authorities to reinstate the petitioner in his services. Mr. A. Chakraborty, learned government advocate, at the outset has basing on the instructions received by him in the matter from the Deputy Commissioner Dhubri, submitted that the departmental proceeding instituted against the petitioner while issuance of issuance of show cause notice dated 12/8/2025 was proceeded with by the respondent authorities, and an inquiry as directed to be held in the matter was also concluded. He submits that the inquiry officer has already submitted his inquiry report, which was received by the disciplinary authority on 21/2/2026. Mr. Chakraborty submits that the said inquiry report having come on record, the disciplinary authority now would proceed to consider the same and would close the departmental proceedings and would conclude the departmental proceedings instituted against the petitioner by passing a reasoned order in the matter. Mr. Chakraborty submits that in view of the said developments taking place and the inquiry having already been completed, this court at this stage would be pleased to refrain from passing any directions requiring the reinstatement of the petitioner into his service. This is the arguments from both sides. I have heard the learned counsel for the parties and perused the materials available on record. The petitioner was placed, but the facts as noticed herein above are not in dispute. The petitioner, for the reasons as noticed herein above, came to be placed under suspension while issuance of an order dated 10/2/2025. A perusal of the order dated 10/2/2025 on a perusal of the order. This court finds that the said order was so issued by the District Commissioner to read, invoking the provisions of Rule 6 bracketed 1 bracketed small c of the Assam Services Discipline and Appeal Rules 1964. The said order suspension having been effected under the provisions of Rule 6 bracketed 1 bracketed c of the said rules of 1960. The same being relevant is extracted herein below. So, page 429 of the Senate. Suspension. 1 to Marigal. AB.D. A perusal of the provisions of Rule 6 bracketed 1 bracketed C of the said rules would reveal that the appointing authority or any authority to which it is subordinate or any other authority empowered by the governor in that regard may place a government servant under suspension where against such government servant a case is pending can place a government servant under suspension where a case against him in respect of a criminal offense is under investigation, inquiry, or trial. The provisions of section 6(1)(c) mandates that the appointing authority can place a government servant. The competent authority can place a government servant even when a criminal offense is in the stage of investigation, inquiry, or trial. In the present case, admittedly, there was a criminal case instituted against the petition. And the same is presently pending trial. However, what is to be noted in the present case is that the petitioner, the respondent authorities thereafter proceeded to drop a departmental proceeding against the petitioner while issuance of a show cause notice dated 12/8/2025. Accordingly, 6 Puram 6/1/12 Puram 1 to Puram. Accordingly, in the present case, the order of suspension that was initially passed under the provisions of 6(1)(c) was converted to one under section 6(1)(a), which postulates that a government servant, a competent authority can place a government servant in contemplation of place a government servant under suspension, also in contemplation of withdrawal of a departmental proceeding against him. Accordingly, this court would proceed in the matter considering the suspension of the petitioner to be one having the facets of having the flavor of Rule 6(1)(a). Mr. J.I. Barbhia, in his submissions, had also submitted that the decision of the Honorable Supreme Court in the case of Ajay Kumar Chaudhary being with regard to the period a person, government servant, can be placed under suspension, had submitted that the suspension, even if effected under Rule 6(1)(c), the decision of Ajay Kumar Chaudhary will squarely apply when a plea of prolonged suspension is raised by the delinquent employee before this court. Full stop. This court having already concluded to proceed in the matter by construing the suspension of the petitioner to be one so affected in contemplation of trial of departmental proceedings. The issue as to whether the decision of the Honorable Supreme Court in the case of Ajay Kumar Chaudhary would also apply to a suspension issued under the provisions, invoking the provisions of Rule 6(1)(c) is not gone into, and the same is kept open to be decided in an appropriate matter. We'll come back at.
Please, Your Lordship. Item number 47, the last order. My lord had fixed the matter at 2. So my lord.
Sorry, we are not in a position to do it today. We have many pending matters.
My lord may.
We'll have to dictate those orders.
There is an urgency in the matter. My lord
Can't
may.
help it. I can't help it.
Let the matter reach them, my lord.
Matter will reach after we finish our dictation of the orders. I don't think so. Might take a long time. I'll have to give primacy to that. I don't know, I have this habit of carrying things there and it gets accumulated. So I'm now changing. Everything will be finished here.
My lords may just.
I'm sorry, can't help it. I don't know. If I finish it off and the other matters get over, we will surely hear. No problem.
My lord.
At 2 p.m. and there is a matter fixed, motion matter fixed, I'll hear that. Then continue with my dictation. One matter, then there is another matter of Mr. Descartes. We'll finish it off. And thereafter, if time permits, we'll take up the other matters.
My lord.
Mr. Chaudhary.
Milord, there was an item.
We had
I understand Lordship is having some other matters.
2 dictations are there. Before that, I cannot take it up. I'll have to just.
Some other day.
Okay. Have you informed the other side?
Yes,
Then
we'll inform them, Milord. Definitely will
you
do
need
that.
not be here. Let Mr. Sharma be here. Contested matter. So let them also.
Deep Lord. See, I'll be in the midst of a matter in court number 3.
You please leave. No problem.
Supplementary list, item 56.
The present matter has been listed today in view of a typographical error, inadvertent typographical error occasioning in the order dated 11/3/2026. So, in the order dated 11/3/2026, the matter was, registry was directed to list the matter again on 23/2/2026 in lieu of 23/2/2026, in lieu of 23/3/2026. Also, this court has considered the matter and finds that accordingly, the date 23/2/2026 occasioning in the penultimate paragraph of the order dated 11/3/2026 shall be read as 23/3/2026 for all intent and purpose. Accordingly, registry to list this matter again on 23 to 2026.
23 to
3, sorry. 2 was in 3 only. I'm sorry, but it didn't come to my notice also. Ekimanol, kili. So, admittedly, in the present repetition, the writ petition was placed under suspension by an order dated 10/2/2025, and admittedly, within a period of 90 days therefrom, the disciplinary proceeding was not instituted against the petitioners. Accordingly, the said instituted against the petitioner. Accordingly, the said writ petition. Accordingly, the said order of suspension would be required to be held to have lost its force. However, considering the fact that the respondent authorities had instituted a disciplinary proceeding against the petitioner here, by issuance of a show cause notice dated 12/8/2025, and the said proceeding during the pendency of the present proceedings has also been and during the pendency of the present proceedings, the inquiry in the departmental proceeding instituted against the petitioner has also been concluded with the inquiry officer submitting his inquiry report in the matter. This court, in the facts and circumstances of this case, at this stage refrains from directing for the reinstatement of the petitioner in his services by revocation of his order of suspension. Also, considering the facts and circumstances involved in the present matter, this court passes the following directions. Also, the inquiry report submitted by the inquiry officer to the district commissioner, Dhubri, shall be, have you received it? You have not received it?
No, man, I have not.
Shall be forwarded to the petitioner within a period of 7 days from the date of receipt of a certified copy of this order by the district commissioner, Dhubri. The petitioner, on receipt of the said inquiry report, shall submit his representation thereon within a further period of 15 days from the date of receipt of a certified copy of this order. The deputy district commissioner, Dhubri, on receipt of the representation from the petitioner within the period as mandated herein above, shall proceed to consider the inquiry report, the materials coming on record in the inquiry, as well as the representation submitted by the petition against the inquiry report, and arrive at his conclusions in the matter, and dispose of the disciplinary proceedings by way of passing a order as is mandated. Also, in the event the petitioner, after being served with the copy of the inquiry report for a period of 15 days therefrom, does not submit his representation against the same, it will be open to the deputy district commissioner to proceed with the matter, and by considering the inquiry report as well as the materials coming on record in the inquiry, to draw his conclusions and pass appropriate orders in the matter. Also, within the deputy commissioner within period issuing days thereafter in a period of 1 month. Also, one month from the receipt of the certified representation from the petitioner. Order pass koribo. Tato follow to 1 month. Also, in the event no order is passed within a period of 1 month from the date, 1 month mane 30 days period of 30 days 30 days from the date of receipt of the representation from the petitioner, and if no representation is so received, 30 days after the lapse of 15 days from the date on which the inquiry report was submitted, which was furnished to the petitioner, served upon the petitioner, the suspension order dated, the currency of the suspension order dated 10/2/2025 shall cease to have any effect, and the petitioner would be required to be reinstated in his services against a post that would be so determined by the respondent authorities in the respondent authorities. Full stop. With the above observations and directions, the present writ petition. So we are not reinstating you, but if they don't pass it, you're coming.
I had the expectation of reinstatement.
I would have, but they have proceeded with the matter. So why?
But my lord, 90 days they have not, my lord, followed.
We got it. That's why we have specifically said only in the facts of this case we are doing it. And in the facts of this case, because the allegation against you is very serious, and I don't know what is there in the inquiry report. And the another problem.
Allegation, my lord, the court has not taken any cognizance.
No, forget it. That is criminal case. The another thing problem here is you are in a district establishment. The matter ends at the district commissioner's level. You will have to be kept somewhere there only. There you may have a nexus. Means Ajay Chaudhary, para 21, second part. It will not be possible for the district commissioner to post you outside the district. So again, bringing the government into the matter will delay the whole thing further. That is why I have taken recourse to this.
Obliged.
But Mr. P.K. Desa, learning counsel for the petitioner. Who was there? Mr.
I thought, Dixit Gogoi.
Mr. D. Also heard Mr. D. Gogoi, learned standing counsel, Forest Department, appearing for all the respondents. The petitioner in the present proceeding has presented a challenge to a gradation list of foresters grade 1 dated 1/6/2025, wherein his name has been, wherein against his name it has been recorded that his promotion was kept under seal cover. The petitioner has also prayed for a direction upon the respondent authorities to open the seal cover, wherein the recommendation in his case of the departmental promotion committee for promotion to the rank of deputy ranger is kept. And to promote the petition to the rank of deputy ranger, deputy commissioner, the deputy ranger with effect from the date his juniors were so promoted in pursuance to the same selection process. What?
He's saying the BTC council, his name may be required.
In from the same selection process, wide order dated 29/8/2023. You are appearing for?
Lordship, respondent number 3, 4 and 5, Lordship.
Upor D. Gugoi 1 and 2. And Musahari, DC Musahari, Learning Council. So the affidavit was filed by you.
No, Lordship.
Who had filed this affidavit?
Forest Department, Lordship. Dixit Gogoi, D. Gogoi, Lordship.
No affidavit was filed. That is the affidavit in the earlier.
Alia, no affidavit in this case, man.
Nothing.
Okay. Also, as projected in the petition, the petitioner on his selection had joined as Forester Grade 1 with effect from 11/12/1992. The petitioner, while working in such capacity at Tamulpur Range Headquarter, Baksa Forest Division, Musalpur, came to be placed under arrest in connection with ACB case number 2/2023 registered under section 7 bracketed small a of the Prevention of Corruption Act 1988. As a consequence of the petitioner being placed under arrest and having remained behind bars for more than 40 and being detained for more than 48 hours, the petitioner came to be placed under suspension. Wide an order dated 4/2/2023 issued by the Divisional Forest Officer, Pansiri Division, Udalguri. Also, the petitioner moved before this court by way of instituting a bail application being BA number 622/2023, praying for enlarging him on bail in connection with the said criminal case instituted against him. This court-wide order dated 21/6/2023, 24/2/2023, passed in the said bail application, proceeded to enlarge the bail, petition on bail, in connection with the said criminal case. Also, the petitioner also assailed the prolonged suspension occasioning in his case after being put under suspension by the order dated 4/2/2023 by way of instituting a writ petition being WPC number 3289/2023. Mr. Dekka, just see if there is any error, just tell me.
The date is 21/6/23.
Which one?
21/6/23.
No, that is this case.
Yes.
This court, just find out if there is any error.
Yes,
just
my
tell
lord.
me. This court-wide order dated 21/6/2023, considering the prolonged suspension occasioning in respect of the petitioner hearing, prolonged period of suspension occasioning in respect of the petitioner hearing, was placed wide order dated 21/6/2023 to direct for the reinstatement of the petitioner in his services. Also, the said developments taking place, the respondent authorities had wide issuance of a show cause notice dated 4/8/2023, proceeded to institute a departmental proceeding against the petitioner. The petitioner participated in the said departmental proceeding, departmental inquiry so instituted against him, and instituted against him. Also, during the pendency of the said during the pendency of the said departmental proceeding instituted against the petitioner, comma, the Departmental Promotion Committee meeting was convened to consider the case of eligible incumbents in the rank of Forester Grade 1 for promotion to the vacant posts available in the rank of Deputy Ranger. The petitioner in the list as placed before the Departmental Promotion Committee, list of eligible Forester Grade 1 as placed before the Departmental Promotion Committee, comma, the name of the petitioner figured at serial number 173 thereof. Also, the Departmental Promotion Committee, on noticing that there was a pending departmental proceeding, that a departmental proceeding was already instituted against the petitioner and the same was not concluded, comma, proceeded to keep the recommendation made in respect of the petitioner for the purpose of the said promotion in seal cover until finalization of the said departmental proceedings. Also, the recommendations of the selection committee of the Departmental Promotion Committee on being accepted by the competent authority, comma, the recommended candidates came to be promoted to the next higher grade of Deputy Ranger by issuance of an order dated 29/8/2020. Persons junior to the petitioner were also so promoted. Also, the departmental proceeding instituted against the petitioner was proceeded with by the respondent authorities, and on conclusion of the inquiry officer having submitted his report, comma, and the petitioner also having submitted his representation thereto, comma, the disciplinary authority of the petitioner, wide order dated 5/9/2024, proceeded to consider the same, and on such consideration, comma, the petitioner was acquitted from the said charges, from the charges framed against him. Also, and the acquitted from the charges framed against him, and the departmental proceeding instituted against him also came to be dropped. Further, the period of suspension undergone by the petitioner was also directed to be treated as on duty. However, the disciplinary authority recorded an adverse remark in the said order to the effect that the petitioner is given a chance to rectify his character, and the petitioner was warned not to repeat any such illegal activity in the department. Also, the petitioner thereafter, the departmental proceeding having been closed against the petitioner and he not being found blameworthy therein, comma, the petitioner had approached the respondent authorities praying for his promotion to the rank of Deputy Ranger by opening the seal cover wherein the recommendation of the Departmental Promotion Committee in his respect was so kept. The same not having materialized, the petitioner had approached this court by way of filing a petition being WPC number 5638/2024, raising the said grievance. Coordinate bench of this court, while order dated 3/3/2025, was pleased to dispose of the said petition with a direction to the petitioner to with a direction to the respondent authorities to dispose of the representation preferred by the petitioner in the matter. Also, it is projected by the petitioner that the representation was not disposed of. However, a draft gradation list of Forester Grade 1 as on 1/6/2025 was circulated, and therein, against the name of the petitioner, it was recorded that his case for promotion was kept under seal cover. It is in the above background that the petitioner has instituted the present writ petition. Mr. P.K. Dekka, learned counsel for the petition, after reiterating the facts noticed herein above, had submitted that the petitioner not being found blameworthy in the departmental proceedings instituted against him, and he having been acquitted of the charges so framed against him, the bar that was existing with regard to his promotion to the rank of deputy ranger ceased to operate, and the petitioner was, and the recommendation so made by the, in respect of the petitioner, by the constituted departmental promotion committee was required to be opened, and basing thereon, the case of the petitioner was mandated to be considered for promotion to the rank of deputy ranger. Also, Mr. Dekka, in this connection, in support of his such submission, has placed reliance on the decision of the Honorable Supreme Court in the case of K.V. Janaki Raman versus Union of India and others, reported in 1991, AIR 1991, Supreme Court 2010. By referring to the order, Mr. Dekka, by referring to the order dated 5/9/2024, more specifically to the observation made therein by the disciplinary authority, has submitted that the said observation, although would at a glance seem to be an adverse comment, actually the same was in the form of an advisory only. He submits that the said comment as made by the disciplinary authority in the order dated 5/9/2024 cannot be construed to be a bar for consideration of the case of the petitioner for promotion to the rank of deputy ranger. Mr. Dekka has further submitted that the criminal proceeding as instituted against the petitioner is still pending at the preliminary inquiry stage, and accordingly, in terms of the decision of the Supreme Court in the case of K.V. Janaki Raman, the same also cannot be construed to be a bar for the purpose of for the purpose of effecting promotions in respect of the petitioner herein, in terms of the consideration extended to him by the Departmental Promotion Committee for his promotion to the rank of deputy ranger. Also, in the above premises, Mr. Dekka submits that the petitioner hearing submits that this court would be pleased to direct the respondent authorities to open the civil cover wherein the recommendation in respect of the petitioner is so kept by the Departmental Promotion Committee in pursuance to considering his case in the meeting of the said committee held on 7/8/2023 for promotion to the rank of Deputy Commissioner, Deputy Ranger. Mr. Decker submits that even his juniors having been promoted from the same selection process wide the order dated 29/8/2023, the petitioner would also now be mandated to be so promoted with effect from the date his juniors were so promoted. That is with effect from the date. That is with effect from 29/8/2023. Anything more? Nothing?
Yes.
So, per contra, Mr. Gogoi's name I'll put because he had argued.
He was.
Per contra, Mr. D. Gogoi, learned standing counsel, Forest Department has submitted that considering the nature of the allegations existing against the petitioner, a criminal proceeding being pending against him, this court at this stage would be pleased not to direct the respondent authorities to open the seal cover, wherein the recommendation of the Departmental Promotion Committee in respect of the petitioner for his promotion to the rank of Deputy Ranger is presently kept. He submits that such a process would be mandated to be carried out only after the petitioner is exonerated in the criminal proceeding instituted against him. Mr. Gogoi has fairly submitted that the petitioner in the departmental proceeding instituted against him was not found blameworthy by the inquiry officer, and the disciplinary authority had agreed with such findings of the inquiry officer. He submits it is on account of the said position that the petitioner was acquitted from the charge framed against him by the disciplinary authority by the order dated 5/9/2024. Mr. Gogoi, by referring to the affidavit filed in the matter filed by the respondent authorities in the earlier round of litigation, that is in the proceedings of WPC number 5638/2024, submits that the remark as recorded by the disciplinary authority in the order dated 5/9/2024, after acquitting him from the charges framed against him, was only in the nature of an advisory, and the intention was not to tarnish the reputation of the petitioner, but was rather to caution him not to resort to any possible wrongdoing in future. He further submits that the said observation in no way undermines the acquittal of the petitioner from the discharge of the petitioner from the charges leveled against him by the disciplinary authority. Also, I have heard the learned counsel for the parties and peruse the materials available on record. The facts as noticed herein above are not in dispute. It is also not in dispute that the criminal proceedings instituted against the petitioner is presently only pending in its preliminary inquiry stage. The petitioner was subjected to a departmental proceeding wide issuance of a show cause notice dated 4/8/2023, and the same had concluded with the issuance of a order by the disciplinary authority dated 5/9/20, wherein the petitioner was discharged of the charges framed against him, and the disciplinary proceedings came to be dropped. The operative portion of the order dated 5/9/2020 being relevant is extracted here and below. Page 33, A to A. A perusal of the operative portion of the order dated 5/9/2024 would reveal that the conclusion drawn by the inquiry officer that the petitioner was not guilty of the charges framed against him was accepted by the disciplinary authority. And it is on the basis of such conclusions drawn by the disciplinary authority that the petitioner was acquitted from the charge so framed against him in the departmental by the show cause notice dated 4/8/2023. However, upon acquitting the petitioner, it is found that certain remarks came to be made against the petitioner by the disciplinary authority in the said order. This court has again perused the said remarks so made and is of the considered view that the same in no way undermines the discharge of the petitioner from the departmental proceedings instituted against him, and the said remarks were only in the nature of an advisory and cannot be deemed to be as to be so passed to be so issued by way of as a measure of penalty. Also, having drawn the said conclusions, this court finds that the cloud which was hovering over the petitioner during the pendency of the disciplinary proceeding against him stood removed with the passing of the order dated 5/9/2024. The petitioner not being found blameworthy in the departmental proceedings instituted against him, the petitioner was entitled to have for promotion to the next higher rank of deputy ranger, provided the departmental promotion committee had found him fit for the purpose. During the pendency of the departmental proceedings against the petitioner, the constituted departmental promotion committee had met on 7/8/2023 for considering the cases of the eligible foresters grade 1 in the zone of consideration for promotion to the next higher rank of deputy ranger. The petitioner was in the zone of consideration and in the list of foresters grade 1 placed for consideration before the departmental promotion committee. The name of the petitioner figured at serial number 103. It is to be noted that the petitioner also belongs to the scheduled tribe Plains community. The departmental promotion committee, considering the pendency of a departmental proceeding against the petitioner, had, after considering his case, kept the recommendation made in his favor in seal cover. Also, the Honorable Supreme Court, in its decision in the case of A.V. Janaki Raman, had laid down that The seal cover procedure resorted to in respect of a delinquent employee shall continue till shall in its decision in the case of K.V. Janaki Raman had held that the recommendation made by the Departmental Promotion Committee shall continue to remain under seal cover till the petitioner is exonerated from till the departmental proceedings instituted against the delinquent employee is concluded and the delinquent employee is exonerated from the charges framed against him. It also held that the seal cover would be thereafter also mandated to be opened in the event the delinquent employee is not found to be blameworthy in the departmental proceeding so instituted against him. K.V. Janaki Raman, Supra So, in the case on hand, the petitioner having been not found to be blameworthy in the departmental proceeding instituted against him, the respondent authorities on conclusion of the departmental proceedings with the passing of the order dated 5/9/2024 were required to open the seal cover, wherein the recommendation of the Departmental Promotion Committee in respect of the petitioner for promotion to the rank of deputy ranger was so kept. There was also further the departmental proceedings instituted further the criminal proceedings instituted against the petitioner having not concluded and a charge sheet not having been filed in the matter till date, the said proceedings also could not have acted as a bar from the respondent authorities proceeding to open the seal cover, said seal cover. Also, accordingly, this court is of the considered view that in the present case, in the present case, there exists no bar after the passing of the order dated 5/9/2024, restraining the respondent authorities from opening the seal cover, wherein the recommendation of the recommendation rendered by the Departmental Promotion Committee in its meeting held on 7/8/2023 with regard to the suitability of the petitioner for promotion to the rank of deputy ranger is so kept. Also, in view of the above conclusions reached by this court, this court passes the following directions. 1. The respondent authorities shall open the seal cover, wherein the recommendation made by the Departmental Promotion Committee in its meeting held on 7/8/2023 with regard to the suitability of the petitioner for promotion to the rank of deputy ranger is so kept. On opening of the said seal cover, it is found that the petitioner has been recommended for such promotion by the constituted Departmental Promotion Committee, the respondent authorities shall issue orders promoting the petitioner to the rank of deputy ranger with retrospective effect, that is with effect from the date persons promoted in date juniors to the petitioner in the cadre of rank of forester grade 1 were so promoted, wide order dated 29/8/2023. Oh, sir. The petition now being directed to be promoted with effect from promoted to the rank of deputy ranger with retrospective effect, comma, in the event he was found to be suitable by the departmental promotion committee, would raise an issue as to the consequential benefits that would now be required to be so granted to the petitioner. This court, considering the factual matrix involved in the matter, is of the considered view that while the petitioner would be now required to be so promoted with a retrospective effect, that is, with effect from the date his juniors were so promoted in pursuance to the order dated 29/8/2023, with consequential seniority, comma, the pay of the petitioner shall also be fixed with effect from the date such retrospective effect has been given to him, to his promotion. However, the arrears of pay due to the petitioner would be released to the petitioner only with effect from 6/9/2024, that is a day after the passing of the order dated 5/9/2024 by the disciplinary authority. The exercise that would now be mandated to be carried out for compliance of the directions passed herein above shall be initiated and concluded by the respondent authorities, more particularly by the respondent authorities within a period of 2 months from the date of receipt of a certified copy of this order. With the above observations and directions, the present petition stands disposed of.
Much obliged.
Obliged.
I mean, yes.
May I please, Lordship, I've got the instructions, my lord. And my lord, Lordship sees due to lack of budget provision, my lord, in respect to the head of account during the financial year 19 and 20.
Now who will pay? Now the secondary education
Now the secondary will pay, my lord, because my lord, if your lordship sees the main thing also, the
Call the secondary. Who is the secondary?
my lord,
Now, because of their Assamese word, Maki, man did not get his money. Now, how long will you take? 5 years, 6 years? Give me, I'll put it on
proposal to 19 pathaisilo, July 19. Due to lack of budget provision, we could not, head of account Nasla, we could not pay. I think the Arrears proposal could not be processed. The next
childish reasons.
roll of certificate was already lapsed. That's what COVID.
Yes, Mr. Fukon, if that certificate had lapsed, don't you know that the certificates lapse after a year? Was it not your duty to promptly ask the concerned person to give a certificate? Why was that not taken? Why that step was not taken? Huh?
I agree, my lord. But my lord,
Agreements
some
now
overlook,
that
my
these questions are being asked for us so that we can compute the interest that has to be given now.
that would not
Guaranteed. Yes, Mr. You can't make any submissions today because you will have to take instruction. How long will you take?
Not 1 week time. I'll get my instruction.
Mr. A. Fukan, learned Standing Counsel, Elementary Education Department has placed on record the instructions received by him. The Director, Joint Director, Elementary Education Assam
Yes.
has informed Mr. Fukan that has informed Mr. Fukan about the reasons as to why the area salary of the petitioner could not be released by this court when the matter is taken up for final disposal. And the quantum of interest required is considered requisite to be awarded to the petitioner for the delayed payment of his salaries. The joint director in a set instructions had also projected that the school of the petitioner now having been amalgamated with the high school, the matter pertaining to with effect from 25/4/2022, the matter pertaining to release of arrears salaries would now be required to be considered by the Secondary Education Department. Mr. B. Kaushik, Learned Standing Counsel, Secondary Education Department, in view of the above position, submits that he be granted 2 weeks' time to complete his instructions in the matter. Prayer accepted. Petition registry to list this matter again. 2 hafta bishod dia. 2 hafta, 3 hafta dia. On 8/4/2024 for further hearing.
Published.
I'll see. That's why I've kept it. I'll see.
No, 37. Secondary division. No.
Yes. Who is appearing? Yes, Mr. How can this be? Novarun Medhi from school A to school B in the same district. That cannot be a bar now under the 2018 Act, if it is within the same district. Yes. (15/11/2025). What is your instructions, by the way? Notices were issued on 2/3. Nothing. Blank.
Not yet received.
Normally, how long should we keep these dates for your authorities to give us instructions so that no instructions submission doesn't come? What would be the appropriate time gap between 2 dates?
It comes well, usually in some matters.
I have not seen it. I have not seen it.
Lordship.
How long would be the gap? What do you think? Means as a seasoned person in this field, what would be the time gap? You can give me, I'll ask the registry to place it before the Chief Justice so that order SOP can be issued. That every case, Education Department will be given X dates, number of days to get the instruction. We find it, instructions come. If in the morning I ask, afternoon the instruction come, but never after 2 weeks or 1 week. 1 year, 6 months, 3 months. We are here. We'll do. You think over it. Next time I come and get to preside over bench 2, I'll ask you. Yes. Now, what do you say on this?
It's not a bar, my lord.
It cannot be a bar. Now, is there any other deficiency on part of Mr. Ayat Soikia, which we cannot see?
Let me give 1 week time, my lord. I'll get my instructions. I'll try to.
Why not? This matters. Why so much time? Okay, returnable date. By following the convention, I give him one more date. Mr. I.H. Soikya, learned counsel for the petitioner, submits that the petition fulfills all the requisite eligibility criteria for being promoted to the post of headmaster of a provincialized school. And accordingly, he is to be deemed to be eligible to hold the charge of the post of headmaster on in-charge basis. He submits that on the post of headmaster in Milan High School, falling vacant on the incumbent therein proceeding on retirement on reaching the age of superannuation. The Director, Secondary Education Assam, while order dated 7/2/2026, had allowed the jurisdictional inspector of schools to hold the charge of the said post. Mr. Saikia submits that in the said school, it is only the petitioner who fulfills all the requisite eligibility criteria as set out under the provisions of Rule 14 of the Assam Secondary Education (provincialized schools) over Rules 2018 to hold the post of headmaster either on regular and or on in-charge basis. However, he submits that the petitioner, having been transferred to the said school by an order dated 15/11/2025, basing on his own request, the petitioner was held to be not eligible for promotion to the said post, was held to be not eligible to hold the charge of the said post. Mr. Soikya has referred to the provisions of Rule
29, my lord. 29, my lord. (29)(2). Page 46.
I got the wrong book, that's the problem. Provisions of Sub-Rule 2 of Rule 29 to project that it is only when an employee is transferred, on his own request, to a school in another district, the forfeiture of seniority of the earlier school occasions. He submits that the petition, having been promoted from one school to another situated in the same district,
Transferred.
Promoted, from one school to another in the same district, forfeiture of his seniority in his earlier school would not occasion, and the petitioner would carry his seniority from his former school to the transferred school. Also, Mr. P. Kaushik, learned counsel for the petitioner, submits that the matter be taken up on 26/3/2026, on which date he shall complete his instructions in the matter and apprise the court as to why the petitioner was not allowed to function as the in-charge headmaster of the school by the Director of Secondary Education Assam. Registry to list this matter again on 26/2/2026 for further hearing. Hopefully.
I'll get it.
Hopefully.
I'll get it.
We may not get you, that's the problem.
I have marked in my diary.
I have not read it. So Mr. Soikya may take me anywhere. We don't know.
I have 3 grounds in this case, my lord, challenging the.
What is the fact? What is the fact?
The petitioner before OCB was working as my lord inspector of schools in Sirang.
Inspector
of schools, Sirang. He has been transferred by an impugn order, my lord, to Dhuburi.
When did you join at Dhirang? Where are you
2024,
posted?
madam.
IS?
2024, my lord.
IS?
Inspector of Schools,
Where?
Sirang, my lord.
Sirang. Okay. When did you join there initially?
2024, my lord.
24 which month?
March month.
The home district is?
Kokrajhar, madam.
Not Sirang.
Not Sirang. My first ground of silence is that, my lord, I am retiring on 28/2/2027.
27.
27.
Of body.
Less than 1 year, my lord. Less than 1 year. 11 months.
Where is the earlier order of transfer?
Earlier order of transfer also will find page 19, my lord.
16 is the fresh one. No, this is the
Page
15
one
to
is page
24.
45, my lord. Page
So what is
45.
the 16? That is your transfer to
That was a transfer from Shirang to Udalguri, which
what
was
is your name in page 14, 16?
16 first one.
Vijay Vaishnav.
His first transfer was
Posters.
2019.
Udalguri.
Shirang is 19.
Then from Udalguri, you joined in this. 16 you joined.
My lord, this order, against this order, my lord, there I have opposed this honorable court. There is a, my lord, status quo order operating.
24.
Yes, my lord. There is a status quo order operating.
So when did you reach Sirang?
19.
Sirang 19.
So okay.
Sorry.
So
19.
Chirang, you were there from 2019.
19.
2020.
Where is that? Where is that statement that you joined Chirang on such and such date?
Four, my lord.
Okay, 7/11 modified and 27/11 you joined.
But that too is
19.
That too is Kokrajhar, my lord.
Huh?
That too is Kokrajhar, my lord. Shirang, my lord, statement is not there.
Oh, Kokrajhar.
Kokrajhar.
This is Kokrajhar.
Kokrajhar. And how did you
come to
paragraph
Sirang,
3?
paragraph 3, my lord. 25/2020, my lord.
25/2020.
25/20? So in 24, you were sought to be transferred. Right. Then what happened?
Then, my lord, I oppose this honorable court, my lord. This honorable court, my lord.
Where is that order?
Page 26.
Page 26. 11%, my lord. Page 27, my lord.
What happened to this case? Pending.
Pending, my lord. Not yet listed thereafter, my lord.
So this was the order of transfer from
Sirang to Udalguri, my lord. The earlier order was not stayed, my lord. Status quo was directed to be maintained. But if the status quo is operating, but perhaps, my lord, without leave of this honorable court, my lord, they cannot transfer me, my lord, from out of Sirang.
What is this Santanu Kumar, Simanta Kumar Deka?
That is, in the case of Simanto Kumar Dekha, my lord, what happened, my lord, I said, my lord, I took 3 grounds in this case, my lord. First of all, my lord,
this is that spouse post.
Spouse posting, my lord. My wife is working at, my lord, Kokrajhar, my lord. He's a vice principal of a high secondary school, my lord.
Hmm. Hmm.
My lord, if I was to be transferred, well, I should have been transferred to Kokrajhar. The figure of my examen, my lord.
You want to go to Kokrajhar?
I can
go.
go.
Why?
My lord,
Last fag end of your career,
my family is
not
there,
1 year, how will you be transferred? You cannot be transferred.
I will stay at Sirang, my lord.
Huh?
I have no objection in
In
staying
staying
at
in
Sirang.
Tirang.
Sirang, my lord.
But you don't have any you have an objection in moving to
Dhubri, my lord.
Dhubri. You don't have an objection in moving to Udal.
Kokrajhar, my lord. Kokrajhar.
Kokrajhar.
As my family is there in Kokrajhar, my lord.
That is a order that is gone. This is a fresh order. So this will be fresh. SC Saxena, you will have to join, then make a representative.
My lord, SC Saxena, my lord, does not have any universal application, my lord. What I am saying, my lord, because my lord, SC Saxena,
For the
in
interim
that
purpose,
case, my lord,
who is coming in your place?
no one has been, my lord, appointed in my place, my lord. I have not been replaced, my lord.
You are in deputation with the Bodoland Territorial Council.
Yes.
Hmm?
Yes.
Have they released you back
No.
to the government?
No.
Mr.
That instruction I'll have to take is.
Because once you have deputed him,
Yes, my lord.
he becomes their thing.
Their-
They will
Yes.
post him wherever they want.
Yes,
How can you issue this order?
that's,
Huh?
I'll have to take instruction on that. Because the earlier postings were within BTC.
PTC. The earlier order was issued by PTC,
No, it was
No, no.
issued by the government,
by the government.
by the government.
No, once you are placing him, he has not brought those.
But the
materials.
first transfer order would have been relevant, my lord.
Because once you place him in Bodoland Territorial Council. Thereafter, it is they who will post him.
Hmm.
Now, if you want him back, you will have to get him released. And then he becomes again your subject and you can then transfer him. But how can you transfer him within Bodoland Territorial Council? Heard Mr. Ayek Soikia, Learned Council. You just have your instructions. A Learned Council for the petitioner. Also heard Mr. P. Kaushik, Learned Standing Council, School Education Department, appearing for the School Education Department, and Mr. B.C. Mushahari, Learned Standing Council, PTC. The petitioner in the present proceedings has, where is that impugned order?
In order, my lord, that says 45, my lord.
Has essayed an order of transfer dated
11/2, my lord.
11/2/2026, transferring
11/3, my lord.
11/3/2026, transferring and putting the petitioner
Serial number 2, my lord.
as posting the petitioner as inspector of schools, as district elementary education officer Dhubri from the post of inspector of schools and district elementary education officer Sirang being held by him. Also, I think he has been released. Thereafter, only this order.
Perhaps, my lord, because this has the approval from the competent authority, because file the routine
He's
transfer.
from Borderland.
My lord.
Yes.
For my instruction, my
And
lord.
it's a routine transfer of all officers, my lord.
You have been released.
So let it be on Monday, my lord, I'll get the instruction. My lord. Let it be on Monday, I'll get the instruction.
Mr. B. Kaushik prays that the matter be taken up on 16/3/2026, on which date he shall apprise this court the reasons, apprise this court as to the reasons existing requiring the transfer of the petitioner. Mr. Kaushik has also submitted that the petitioner was transferred to the Bodoland Territorial Council via a notification dated 7/11/2019, and he has continued in the set under the said council, under the Bodoland Territorial Council since then. Also, in view of the above, raised to list this matter again on 16/3/2026. Ajay Patharia. 16/3/2026. Also, we'll see on that day. Let him get it.
Status quo is.
Yes, it's already there.
Already it is there.
Already status
That
quo
may
is
be
there.
mentioned, my lord.
And my lord,
That may be mentioned in this case also, my lord.
Wife posting, spouse posting, these are all not grounds now.
No, no,
And
this is
basically
not the
the-
only ground, my lord. This is not the
Those
only
were
ground,
grounds
my lord.
when we were
My lord,
that side.
my lord, in the
and the
case of
earlier
Naran
petition
Chaudhary-
also, my lord, the ground was same, but spouse posting. My lord, he cannot have that
in the
luxury
case of
every
Naran
time.
Chaudhary, my lord, in the case of Naran Chaudhary, my lord, this honorable court has set aside the order because, my lord, he was transferred.
No coercive action shall be taken
Malad.
against the petitioner till 16. 16 3/2026.
Get from.
My lord. बोला जाए।
May I please, Lordship? Lordship, they have given affidavit, Lordship, and their Lordship, they have written that they will take appropriate steps. Order was not complied, Lordship. Order is of 2018.
So you have not been provincialized.
No, Lordship.
Where is the affidavit?
Lordship, from page number 28.
It is, you said they have filed an affidavit. When?
Lordship, date was not given here.
When did you file? Who filed?
Malad,
From respondent
give me
number 5.
5 minutes time, Malad. I will find it out.
Can take this file also. I don't find it. Yes.
39.
May please, your Lordship. Lordship, matter relates to non-payment of pension and retirement benefits. Instruction was sought for, Lordship.
Your Lordship, your Lordship later has been received, your Lordship, from the department, that is Inspector of School, written, your Lordship, to DSC, your Lordship, where therein your Lordship reference, your Lordship, that Director of Pension, White, dated so and so, correspondence was initiated with the petitioner by issuing and dispatching a letter to
Where
the
is the order which has been violated? Madam, 1 second.
Not order, Lordship. They have not
No, this is a contempt.
content.
Puzzle Ali.
No.
39 to dear, 42 days. Things are not sinking. I don't know why. That's why I said, not getting it.
Deepak Kumar Sekya.
39.
Deepak Kumar Sekya.
Yes.
May I submit, your
What
Lordship?
is your instruction?
Your Lordship, one letter has been received, your Lordship, dated on 10/3/2026, wherein it was referred that
from the Director of Pension, white dated so-and-so, correspondence was initiated with the petitioner by issuing and dispatching a letter to the address available on the record. However, the communication did not reach to the petitioner and it was returned to the office, which was undelivered. And thereafter, Your Lordship, that Honorable Court, Your Lordship, with a view to finalize, settle the long pending matter, called upon the petitioner, but he did not appear before the court. He also refrained from making any communication with Honorable Court or with the competent authority, Your Lordship.
Honorable court means which honorable court?
Maybe lower court of basic.
We did not want to communicate with him.
Your
Why
Lordship,
should we going and communicate?
Your Lordship,
Show me your letter, show me your instruction.
address is not available, Your Lordship, proper, Your Lordship, the letter has not been
Where is that
dispatched.
letter which was sent?
Page details on first row. Basic thaka kita. Basic thaka kita.
Yes, where is that letter?
Your Lordship already sent it to the mail.
What are they writing all this? Paisa?
And another letter, Your Lordship, that is on communication letter dated 11/9/2025 from Inspector of School Nagaon, Your Lordship, to DSC, Your Lordship, that also I would like to place it. It sounds. Communication letter dated 11/9/2025, Your Lordship. Third paragraph. Certain deficiencies has been found in the proposal, including excess drawal.
Have you carried out this exercise, madam? Have you issued notices to the employee? That is what is required here from the
Yes, Your
director.
Lordship.
Miss Das, can you just call your director and ask him how the process of issuing notices to a dead person is to be done, which is the courier service to be, because he has written here that a notice be issued to the person. Kindly get that. Maybe they have something.
Yes.
They know some courier somewhere who will take it to the other world and then get it to me.
It was going up a hole, but it was not delivered to him. And was displayed.
Then I think it is addressed to
What are they writing all these things? Are they don't know, just to write, they write. Man is dead.
Yes, Lord.
How will the rectification exercise be done? By giving him a notice? Where is the scope of that rectification exercise? Who is your director?
I think because that's Lord.
What is this? He's a AFS officer, senior level AS officer. This is the way he deals. Just pushing the files.
I will obtain instruction. I think it is.
We are here. We are here. You get your instructions. We are here.
Wrongly address policy.
We are here. There is written here, as initiated may be submitted, including in corrective action for treatment of so-and-so, show cause notice to the concerned employee and replies thereof, issue of speaking orders after representation, receipt of representation from the employee, identification of those responsible for overpayment consequent. So ask him how to send this notice. We will ask the we'll pass the order, which is the courier service which takes the notice. And I want that specific answer, madam.
That Lordship,
I want that specific answer.
in letter that 11-9, Lordship.
I don't know that letter, his objection letter. This one, Take
May I
this.
get a copy?
You take this one.
One idea. Look. Motor Nikon. No, I content. I think for 39.
Madam, wait.
Full hole niki. Huh?
You read and then go.
And flag B, madam. Our affidavit. But, Harvey. And paragraph 7, my lord. On 7-3, report was called from the inspector of schools.
When was this order passed?
Long back, my lord, to 2018.
2018. What were you doing for the whole time?
In between, we have prepared a review petition that was dismissed.
When was it dismissed?
That was dismissed.
20,000 cost. When was it dismissed?
That was dismissed with cost, my lord.
20,000?
Yes, my lord. On 6/1/2026, my lord.
Huh?
On January 6th, my lord. This
January.
This January, my lord.
Mr. NJ Khatonia submits that after dismissal of the review petition referred in the matter, praying for a review of the order, judgment and order dated
28/11/2018.
28/11/2018. They passed in WPC number so and so. WPC number?
WPC number, my lord, 5914 of 2014.
5914 of 2014. The respondent authorities are taking the requisite steps for compliance of the directions passed by this court, violation of which is alleged in the present report. He prays that the matter be taken up on when?
After 4 weeks, my lord.
No. Review is nothing. It's just a time-buying thing.
Yes, that. In any case, that was dismissed, my lord.
That is it.
So, in case, my lord, before Bihu.
Before Bihu, we want to have that thing visible. On 31/3/2026, on which day he shall place before this court the developments taking place in the matter. In writing, received from the contemners. From the respondents.
May it please, your lordship. Lordship, my lord's order, page 16, order dated 9/2/2024. My lord, page 20 is the relevant portion, paragraph 12. Direction was given to carry out the recommendation made by district committee and provincial.
Done it. Implied, compliant.
Let's see.
When is the date of my order?
My lord, it was 9/2/2024, more than 2 years.
No appeal, no review.
No appeal, no review. Even my lord, so many times last chance given. My lord, kindly peruse order dated 25/7.
Already under consideration, my lord,
I know.
And for compliance only, my lord, we have initiated.
Why did you wait till this fag end when the what is that?
FinAssam portal.
FinAssam portal would be not accessible. What were you doing after the
No, my
publication
lord,
of this
it
order?
is basically when this proposal was sent before the finance, my lord, they have instructed us to, my lord. The next page, my lord, you can see. based on the finance advice, now we have to submit it. From our end, it was submitted before the finance. And it's a technical problem, we can sort it out, my lord, to lordship will give some more time.
3 months. What were you doing from after you got the certified copy? Only the SLC was to consider.
Well,
And it seems that consideration is in our favor.
well,
Took you 2 years, 1.5 years to make this consideration. 23, 24, 25, 2 years.
well.
And you could get the thing for placing before the government only in 26.
That,
Mr. D. Kaushik, learned counsel for the petition for the respondent submits that the proposal for creation of a post for accommodation of the petitioner for provincialization of the services of the petitioner was submitted to the finance department. However, the finance department had required the submission of the proposal through F to Dangor, IN Horu, A to Dangor, Assam, SS AM to Horu portal. However, on account of certain technical problem arising in this portal, the proposal could not be submitted. He submits that the said technical error would be resolved and the proposal would be uploaded in the portal soon. While the respondent authorities are directed to carry out to submit the proposal for creation of posts in the manner as in the portal concerned, the Director Elementary Education Assam shall, before the next date of listing, file an affidavit and therein set out the manner in which the direction passed by this court was being processed for compliance on a week-to-week basis after receipt of the certified copy of the order.
2 weeks time.
Register to list this matter again after 3 weeks on a date to be fixed.
Grateful.
You mentioned after 3 weeks, we'll do it.
Well,
Now, every day, 1 week, what you did, compile, give it to me. I'll see.
well.
I am did.
Lordship, I request to take the matter for the time being as
You are appearing for?
Proposal has been submitted before the government for creation of postman.
Last communication was also in this trigger. Not only.
11 months.
Okay. Mr. D. Kaushik, learned counsel for the respondents, submits that the proposal for provincialization of the services of the petition has been submitted before the in the Department of School Education on 11/3/2026 and accordingly prays that he be granted 3 weeks' time to apprise this court about the further decision that is taken in the matter by the government. So, prayer accepted, register to list this matter again after 3 weeks on a date to be fixed.
Grateful.
What happened to the mediation?
Well, mediation, they took prayed for some time, my lord. There, matter hopefully it will be solved for mediation. I hope that, my lord, because matter is progressing, my lord. Because it is I am coming covered by the Purnima case, my lord.
In fact,
Okay.
On another date will be fixed.
so the communication which I have received from the director to the secretary also, it has acknowledged that he would be under the old scheme.
Old
yes.
school.
Old scheme.
Then bring that
And
on.
accordingly, the director of elementary education has also been asked
Also.
to pay the seller.
Seen the communication submitted by the mediator, wherein it has been highlighted that some more time would be required
Yes.
to resolve the issue by way of mediation. Also, during the hearing today, Mr. P. Kaushik, Learned Standing Counsel, Elementary Education Department,
Secondary.
Secondary Education Department has placed on record communication issued by the Director, Secondary Education to the Secretary to the Government of Assam, Department of School Education. Wherein it has been observed that where it has been highlighted that the petitioner herein is you are the wife of the teacher.
Yes,
Yes.
Wherein the husband of the petitioner is held to be covered, is entitled to be, is held to be entitled to be covered by the provisions of the Assam Services Pension Rules, that is the old pension scheme, instead of the new pension scheme. Mr. Kaushik submits that appropriate orders in this connection would be passed by the authorities within a period of
3 weeks.
or within a period of 3 weeks from today. Also, in view of the above developments, the Learned Counsel for the parties have submitted that they would desire not to proceed with the mediation process any further. Want to go to mediation?
My lord, the mediator has fixed because.
Okay,
well,
okay.
Let it be
Also-
after, my lord, 4 weeks, that
Also-
in the meantime,
fixed.
mediation.
Hmm.
Then my lord.
Also, in view of the above development
Yes.
taking place, the registry is directed to place the matter before the mediator on (25/3/2025).
My lord,
The mediator is granted further 6 weeks' time
yes.
to complete the process of mediation and submit his report in
My
the.
lord, I've just.
The parties are directed to cooperate with the mediator for an amicable resolution of the issues involved in the matter.
Yes, I have humble submission, my lord, regarding the dates of 25, because my lord, I have been told by my lord, the petitioner that wife is my lord, he has met with an accident, my lord. She is in
Okay,
hospital.
when do you want it?
My lord, in the month of April, that will be.
Okay, on
perhaps.
24/2025.
Yes.
No,
Date in the
too long.
It will be two. Maybe it will be fixed in the first week of April.
April.
If
my lord.
necessary, they can.
Yes.
1/4. It is also provided that in the event the petitioner is not in a position to personally appear before the mediator, she may make her appearance through video conference.
Yes, that's.
Yes.
We'll keep it on 25th only.
Lordship.
25th.
Obvious, lordship.
25th.
Applies.
My lord, a letter of the government of Assam has been shown to us, my lord, by which it agrees to fix the pay as on 30/12/2016. And that may not be, this is a letter, my lord. I don't,
Yes.
It has been complied with, madam. I don't-
এই প্ৰটেকশ্যনটো কভাৰ নকৰিব পাৰে ন মই সেই এফিডেভিটখন থকা হ'লে বৰ ভাল আছিলে তাত এটা
This is a contempt.
Yes, ma'am.
কেলকুলেশ্যন এটা আছিল ন নাই নতুন ফটো মাৰিবলৈ ৱাৰেণ্টি পাৰ্ট দিলেই হ'ব
Yes, what did you do? You have granted this, complied with this.
Yes, my lord.
Where?
First is the forwarding letter. Thereafter, my lord, individual sanction letter has been issued. Sanction of protection of prey in respect of petitioners in both the contempt cases, my lord. The names are
Yes.
there.
My lord, we have not received it and we
I'll-
have seen a copy whereby the government of Assam Education Department is agrees to fix the pay as on 30/12/2026 and whether the full pay protection will be covered or not.
You give him a copy.
I'll
Mr. S. Das, learned counsel for the petitioner. For the respondent submits that the directions passed by this court while the judgment and order dated 16/5/2024. In WPC number, your WPC was?
WPC
In
number.
WPC number 1162/2023 has since been complied. And the compliance order and the orders in compliance of the directions have also been issued. Mr. Das submits that he will furnish a copy of thereof to the petitioner. Learned counsel for the petitioner during the course of the day raised it to list this matter again on 2/4/2026.
similar order. Next item also, only the petition number will change. ma'am.
Petition. Would be the petition number in the second.
It is
T-770/21.
3770 of 2021.
Same order, same judgment, only through petition number. चला गया ना लगा उसको On the prayer of the learned counsel for the parties, a registry to list this matter again when?
30th of March.
30th, 30.
Although there's an interim order that may continue.
Huh? Interim order to continue till the next.
My lord, one more prayer, my lord, the pleadings have been completed, it's coming for orders. Let it become for admission.
There is an interim interlocutory application.
Yes, there's that for that also pleading has been completed, it may come on.
That will be on the orders only.
Most of the-
In the office note, order of the Laujima Court dated 10/3/2026, which reveals that service of notice upon the respondent number 5 is complete. Also, accordingly, registry to list this matter for admission hearing after a week.
Another similar matter fixed on 27th of.
List this matter, registry to list this matter again on 27/3/2026 along with WPC number.
448/2025. 448/2025.
/2024.
Oblige.
Alert, the notice upon the respondent number 4 is served, my lord, as per delivery report attached to the file.
Registry to place this matter before the Laujima Court for ascertaining the service of notice upon the respondent number. Respondent number 4. Registry to list the matter before the Laujima Court.
Well, in a date, my lord, after that, it will be listed.
I'm appearing for secondary.
Speed us, learned counsel for the secondary education department is.
Deeply.
Plus,
No, 43, 44, okay.
43 and 44 are same, but
40
45 is different.
45 is different.
Yes. Lordship,
43, 44 date. 44 to 45 to aforesaid. Yes, what is this?
kindly have a look to the order dated 4/2/2026. Now only the respondent number 2 appears. Earlier, Lordship, direction is at page, your Lordship, with orders from 8 and direction part is page 18, para 21.
আপনার কপি এনএক্স এ বনে
হ্যাঁ?
স্টেপস মতে এনএক্স এ দিয়ে
এইবিলাক আমার সিস্টেম নাই, মই একটা পেজ
আমি বনে
লাগে দিম, মই এখবা লাগে।
মই কোন রেসপন্ড তুমি 1 অর 3 আপনার সার্ভিস কমপ্লিট হল
ব্রেক কনসার্নমেন্ট আছে,
সাইড অফ করে
সার্ভিস
কি
কমপ্লিট হয়েছে, ওটার অর্ডার অলরেডি লিখেছে।
Yes.
মানে because I am entered appear for the first time, my lord, may grant some time to file affidavit.
First time for
Respondent number 2, my lord. And I am also praying for a petition of the contempt, my lord. We have received without annexes, my lord.
nobody is appearing for 1 and 3.
My lord.
They have received notices.
My lord.
And not steps
My
were
lord, may
taken
grant
twice.
some time, my lord. I will take instruction, my lord, from them.
Steps taken twice. As they did not
Yes,
respond.
Shukriya. Learned counsel has entered appearance on behalf of respondent number 2. She submits that. She prays that she be granted a week's time, 2 weeks' time to complete her instructions in the matter. Anwar Hussain, is it the Anwar Hussain who was the DEO?
Yes.
Same one. Place this matter before any other bench without me. He was dismissed.
Dismissed, subsequently compulsory retirement.
But he's retired now.
Division bench,
He's retired.
yes.
He was A. Mojumdar's client. This is that appeal.
In appeal perhaps.
Appeal. He's the one, Sipsagar, he was posted.
Yes.
For any other.
Next week, any date, Lordship.
Make a mention. I had appeared for him once. Prepared an appeal for him.
Yes. Appeal was there. In
That appeal I
appeal,
prepared.
single bench judgment was modified and made
Appeal was prepared by me. I think it was argued by A. Mojumdar sir or by SSD, senior advocate. Appeal was prepared by. It's the same man.
Yes,
That
absolutely.
Sipsagar,
Yes,
rotation.
absolutely.
May it be pleases you, lordship. Here, your lordship, one instruction that was in available, your lordship, that is 2024. I may allow to your lordship to take up-to-date instruction, your lordship. So kindly grant us
Lordship,
1 week.
let the petitioner counsel be allowed to, Lordship, in this, with the 2 writ petitions are filed.
Both of you allow me to understand what the.
Because Lordship, I have the instruction, Lordship, a pension payment order has been issued in respect of this WBC 34500 of 2023.
Finished.
Because there is a 3 years delay, Lordship, I have also prayed for enhance the interest, Lordship, as per 197A.
Okay. Where is the
Lordship,
PPO?
second, Lordship, I am just praying. And the writ petition, Lordship, 3164/2024 is with regard to, Lordship, recovery of excess drawal of rupees 84,000. 86,154. Lordship, that amount should be refunded to me, Lordship. Even during the mediation process, Lordship, the departmental people, Lordship, they have admitted that, Lordship, that you will get this amount.
So my only limited prayer is that lordship, this amount of 86,154,
What do you want here? Interest.
that prayer is there, lordship.
Where is there? Why should we pay you interest? You are being paid a provisional pension.
Then lordship, that in the second repetition, lordship, that my amount, lordship, which was recovered.
Okay, this first repetition, what do? We close it?
Yes, Lord.
But Mr.
But the amount.
We are closing the first repetition.
Yes.
PPO issue.
GPF.
You have nothing to do here.
We have to sanction the GPF, we have already done that.
Oh, GPF account hobo.
Mr. SK Das, WPC number, this will be WPC number.
WPC number 45000 of
Dhanesh
2020.
Prasad Singh.
Lordship.
Dhanesh Prasad, WPC number
450.
3164-2024, 60. Then 60. Mr. SK Das, Learned Counsel for the petition, submits that
4500.
the petitioner, that the Director of Pension Assam has finalized the pension and pensionary benefits of the petitioner and has issued a PPO in favor of the petitioner. So accordingly, he submits that the grievance raised by the petitioner in the present petition stands. Oh, there is a recovery here.
There is a recovery here, lordship. That is my in the second repetition.
No,
lordship.
first repetition, no recovery.
Lordship, the second repetition was filed, lordship. During the pendency of the first repetition, lordship, they have made recovery. During the pendency of the repetition.
However, he submits that a recovery has been effected from the pension and pensionary benefits authorized to the petitioner. Also, where is the recovery? No recovery.
Lordship, yes. Lordship, recovery is there, lordship. Page 22, lordship, Salan.
You deposited.
Lordship, I deposited.
Okay. Ms. Pidas to complete her instructions in the matter
Thank God.
and complete her instruction in the matter before the next referendum. WPC number 450023. Mr. Das submits that the final pension and pensionary benefits have not been finalized in this. PPO has not been issued.
Lordship,
Oh, same thing.
same thing, lordship. You have the
WPC number
settled-
45002023.
If you have the settled law, lordship, that can be disposed of, lordship, with
But
respect.
I have instructions.
And in you have the finance office memorandum, lordship. Because in that mediation, lordship, they have admitted these facts.
In 4500, I'm there.
You want disposal?
Lordship.
Yes, madam. Why recovery is to be made?
Yes, my lordship, in this case, lordship, recovery, lordship, will not be made, lordship. But lordship, the IS lordship, they have lordship, give the reply, lordship, of the what is the exact amount, lordship, will the pension will be payment from.
So he has deposited around 87,000 something.
Yes.
As agreed to by the Learned Counsel for the parties, raised it to list this matter again on 3/2026 for further hearing. We'll see on that day. Now it's too late. Mr. B. Sharma, Learned Counsel, Learned Standing Counsel. AG is present along with Ms. P. Das and Ms. P. Das Burman, Learned Counsel, appearing for their respective. Finally, Ms. B. Sharma. P. Das Burman, Ms. P. Das, Mr. B. Sharma are present for their respective.
I am appearing for respondent 1N.
For their respective respondent. Nobody is going to take your respondent away.
Date to ketia dile dada? Date to ketia dile?
Written opinion already given, both sides.
The Learned Counsel for the parties at length has been reserved.
Lordship. Obliged.
Yes, Mr. Das, matter is going nowhere.
But if something can be done, my lord, why I'm saying so, I'll not take much time, my lord.
Previously,
Well,
lordships has
Not
been,
possible today.
I understand.
Switch is gone.
Lordships has seen the,
I've seen it, marked it also.
yes, my lord. Only thing is that, my lord,
Do one
the
thing.
penalty order of 2022.
You do one thing. Give me a small note.
Yes, my lord.
Can you give the note by Monday?
Yes, my lord.
Hmm? Okay.
2 page
You
or
also
3
give me a
page
note.
note.
My affidavit.
Affidavit is enough.
Enough, my lord.
But the learned counsel for the parties at some length. Hearing remains inconclusive. Eta khali taka did dia. 6/4/2024
My lord.
for further hearing. You give me that. I'll formulate.
Yes, my lord. Yes.
Obliged.
Highly obliged. Last order, my lord. Kindly.
82, my lord, your lordship will give me an accommodation for a week, my lord. The last order, my lord, the instruction which has been sought, and the, my lord, in the instruction which I have received, my lord, it's not the query that has been raised, my lord. Lordship wanted to know that what has happened to that 2012 process, my lord. That is not answered.
Mr. P. Kaushik, Learning Council, Learning Standing Council, Elementary Education, Secondary Education Department, says that he be granted time till 25/3/2026 to complete his instructions with regard to the queries raised by this court-wide order dated 25/2/2026. I accepted registry to list this matter again on 25/2/25/3.
Can it be 26 or 27?
27/3/2020.
Obliged.
Yes. This is that letter, courier service. Yes. Where is madam?
Yes, Lordship. In this case, Lordship, by mistake, Lordship, that letter is issued in the name of Lordship employee, Lordship. Actually, it is in the husband of the Lordship employee.
That is not expected from a AFS officer of such. I was very eager that you will give me a courier service who takes the letters to God.
Yes, Lordship, by mistake, Lordship, it is there. And Lordship, that if the IN,
If this is the way your officer
yes,
is
Lordship.
processing
Without-
pension papers, what will happen to this?
Yes, Lordship.
Hmm?
Without verifying the letter, he has.
He is just pushing files. Or there are some other reasons for that.
No, Lordship.
Huh?
No. Lordship, and the Lordship inspector of school, Lordship, is the finalize the pension, Lordship, then the immediately, Lordship, director of pension, Lordship, release the PPO, Lordship. So,
This is WPC or contempt?
Petition.
WPC.
Introduction to multiple instructions.
Okay, madam.
and Lordship, the petitioner will meet the
The
details.
director of pensions on the next date of listing, as well as the inspector of schools, the Nagaon district circle, Nagaon, shall, before the next date of listing, discuss and resolve the issues arising with regard, which is preventing release of pension and pensioner benefits
Yes.
to the petition. On the next date of listing, before the next date of listing, the inspector of schools, Nagaon district circle, shall resolve all the issues arising and forward the pension proposal back to the pension proposal to the director of pensions, Assam. The petitioner, for the purpose, shall approach the director of
Pension.
the inspector of schools, Nagaon district circle, Nagaon,
And submitted.
on.
Already.
When can you go?
Any date, Lordship.
A petitioner on and or her authorized representative.
With all,
Maybe age now.
with all relevant documents.
documents.
And cooperate with the inspector of schools for early submission of the pension proposal. Also, the registry to list this matter again on 22/4/2026. On the next date of listing, the respondent shall apprise this court about the developments taking place after the passing of the order today. And give a copy of that. I'll keep it here. The objections raised by the director and director of no, not this, that directors, that letter.
Entry.
Director. The objections stated to have been raised by the director of so and so. Order to continue. I'll rephrase this order. I'll quote that and then do the.
Slight indulgence, my lord. My lord, item number 47, my lord has fixed on 30th. My lord, can it be at 2 p.m., my lord? There may be. There's urgency, my lord. My lord had last order had fixed it on 2
Can't
p.m.
help it because Mr. You may have an urgency. There are other people's also in the queue.
So, my lord, on 30th, my lord, because this
And I
women
can't-
is suffering, my
because
lord.
I'm not holding the bench anymore, so I can't fix a date. I can't impose myself on other. If it is me holding the court,
So,
then
my lord, then on 31st, it's a Tuesday hearing day. Then
no, I can't put it.
on
Because
31st,
I'm not holding the.
on 31st, my lord had fixed on 30th, then 31st.
I am not holding the bench anymore from Monday onwards.
Absolutely, my lord,
Then
but my lord
How
had
can
fixed.
I direct another court bench to
No,
take
my
up a
lord, today has
matter?
fixed the matter on 30th. I'm saying on 31st, a day prior.
That you will have to get.
Yeah, I
the
have
other-
taken. I'll inform the concern. I'll of the 31st.
You inform me.
I'll
Then
inform
tomorrow
them.
they'll come make a.
No, I'll inform
That-
them.
See, I'll take very serious action.
My lord, I'll
This-
inform.
I'm sorry. But the others not coming, I'm not converting.
I'll inform them, my lord.
You informing them, they may have objections.
My lord, if they have objection, they would say on 31st. My lord.
I can't come and go and keep on changing my orders. 30th.
My lord.
And if all of you come and tell her that we have no objection on 31st, I'll change it before I sign the order.